Labrīt! Cienējamie klātsošie, tie, kas ir šeit uz vietas, un sveicināti tie, kas mūs vēro tiešraidē. Sāksim šo Maksātnespējas kontroles dienesta organizēto starptautisko konferenci, kas ir veltīta Maksātnespējas digitalizācijas jautājumiem. Un oficiālais konferences nosaukums ir Insolvency Goes Digital. Maksātnespējas kontroles dienestam šajā gadā aprit 20 gadi, jubilejas gads, un labs iemesls to es nelietošu vārdu svinēt, bet atzīmēt ar šādu pārskatu par to, kā mums veicas ar digitalizācijas procesiem, un raudzīsim arī, ko kaimiņu un reģionu valstis ir veikuši šajā te sakarā. Mans vārds ir Oskars Spriede, es būšu jūsu moderators šajā te dienā. Šeit, tiem, kas domā, nezinu, no kurienes viņi raida, mēs esam ārkārtīgi skaistā vietā, 27. stāvs viesnīcā Latvija ar skatu uz Pārdaugavu, ar brīvu skatu uz Pārdaugavu. Jūs saprotat, ko es ar to saku. Un šeit mums ir klātienē runātāji un daži tuvākie fani, un tad ir auditorija tur otrpus uz zilajiem ekrāniem. Neliela instrukcija varbūt par to, kā lietot platformu. Es pieņemu, ka tā ir gana intuitīva un jūs visu redzat, bet tomēr mazums. Tad mums ir 3 virtuālas skatuves, tur tādas podziņas virs šī translācijas ekrāna, kur jūs šobrīd redzat mani. Attiecīgi oriģināla valoda ir pirmā skatu, un pēc tam ir tulkojumi latviski, tad, kad būs angliski runājoši prezentētāji, un tulkojums uz angļu valodu visam procesam, kas notiek latviski. So those who are wondering what is happening and don't understand the thing I'm saying, you can check the boxes in the upper section of the window. You can see the English translation as a possibility for you to follow the content in English language, especially in the first part of the conference, which would be held in English, in Latvian. Lūk, tāds ir stāsts par jūsu iesaisti kā aktīviem šī pasākuma, šī notikuma dalībniekiem. Jums ir iespēja rakstveidā platformas ietvaros uzdot jautājumus. Tur pa labi sanāk no jūsu skatu punkta. Jā, tad te kaut kur ir šis lodziņš, kur var uzdot jautājumu, ieķeksējot tad ask via moderator, tas nonāks taisno pie manis. Caur filtru, bet tomēr nonāks pie manis visticamāk, un tad mēs šos jautājumus, ja laiks ļaus un apstākļi un zvaigznes sakritīs, tad noteikti uzdosim arī mūsu prezentētājiem. Tā kā noteikti izmantojiet šo iespēju. Turpat, starp citu, blakus šim te komentāru logam ir arī visas konferences darba kārtība. Varat sekot līdzi un, atķeksēt sev interesantākās un svarīgākās, jūsuprāt, vietas prezentācijas šajā konferencē. Te tāda interesanta atruna par apliecinājumu. Acīm redzot, tiks izsniegts apliecinājums tiem, kas apmeklē šo konferenci, bet tur tāda niansīta. Niansīta ir sakojuši, ka jums jābūt vismaz klātesošiem pusē no konferences, lai saņemtu apliecinājumu par dalību, tātad vismaz 2,5 stundas. Redz kā tā ļoti akadēmiski, bet es domāju, ka ir vērts visu konferenci pavadīt un piedalīties aktīvi. Tā kā Maksātnespējas kontroles dienests ir tiešā tieslietu ministra pāraudzībā, un man ir tādā ziņā ļoti liels prieks, ka tieslietu ministrs ir šodien kopā ar mums, lai apsveiktu Maksātnespējas kontroles dienestu apaļajā jubilejā un arī atklātu šo te konferenci. Tāpēc šajā brīdī dodu vārdu ministru prezidentu biedram, tieslietu ministram Jānim Bordānam. Lūdzu.
Labdien, dāmas un kungi, cienējamie Maksātnespējas dienesta vadītāji, vadība, darbinieki, cienējamie viesi, kas ir gan zālē, gan arī ir attālināti. Un, protams, attālināti, jo šodien konferences nosaukums ir Insolvency Goes Digital. Maksātnespēja ir digitāla, iet digitāla, kļūst digitāla. Tas, ka viss kļūst digitāli, ir var teikt, no vienas moderns trends, jo tiesu administrācija kļūst digitāla, tiesas kļūst digitālas. Mums šobrīd Latvijā notiek liela konference, ko rīko OECD organizācija, pasaules attīstītāko valstu. Tiešām vadītāji, no tieslietu nozares vadītāji ir sanākuši Rīgā, un viņi arī runā par to, ka viss kļūst digitāls. Bet tas nav vienkārši moderns trends, jo Maksātnespējas kontroles dienests kopā ar Latvijas visu valdību un sabiedrību jau pirms daudziem gadiem ir nolēmuši, ka mēs virzamies modernas digitālas iedzīvotāju apkalpošanas un arī savu darbu procesu virzienā. Digitālā pasaule daudzus biedē, jo nāks mākslīgais intelekts un roboti, un viņi cilvēkus izmantos apēšanai un savas enerģijas radīšanai. Bet patiesība ir tāda, ka digitālais ir labs, nākotne ir laba. Mēs vienkāršojam procesus, mēs varam apstrādāt milzīgu datu apjomu, large scale data. Mēs ar šos datus mēs varam izmantot nevis, daži varbūt baidās, manus datus izmantos, bet šie dati tiek izmantot, lai mēs padarītu mūsu dzīvi efektīvāku, mūsu ekonomiku efektīvāku, mūsu darbu efektīvāku, lai mēs cilvēku prāts, cilvēku darbs nav domāts tam, lai viņi, piemēram, kā senos laikos, kaplētu nezāles vai ar rokām strādātu, un arī tagad rakstītu vienkāršus tekstus un darīt kaut kādas fiziskas lietas. Cilvēku prāts ir domāts daudz labākām lietām. Un tāpēc digitalizācija to visu padara iespējamu. Digitalizācija padara mūsu vietā tehnisko darbu. Bet mēs varam domāt par to, kā efektivizēt savu darbu un kā veikt mūsu gadījumā maksātnespējas procesus daudz efektīvākus. Neobligāti vieglākus, bet efektīvākus. Apkopot, un pirmkārt mēs varam, un tas jau notiek, apkopot datus. Tas prasa pareizu datu ievadīšanu, tas prasa pareizu sistēmu lietošanu, tas, protams, prasa arī sistēmas attīstību. Un paldies Maksātnespējas kontroles dienestam par to, ka jau daudzus gadus iepriekš ir izveidota, vai varam teikt vairākus gadus pirms šī brīža, ir uzsākts veidot elektronisku sistēmu. Moderna tā būs vēl pēc kāda laika, tā būs pati modernākā, jo arī tur ir jāinvestē. Es domāju, ka visi saprot, arī valdībā saprot un ministrijā saprot, ka ir jāinvestē gan cilvēkos, gan modernās digitālās ierīces, lai mēs nelietotu kompjuterus, vienkārši runājot, neefektīvi. Un šodien es esmu arī ļoti lepns par to, kā Maksātnespējas kontroles dienests, kā tiesa administrācija paveic savu darbu. Varbūt ne ar tie vieglākajiem, tas nav vieglākais. Es zinu, kā jūs nākat un norādat uz jūsu vajadzībām. Uz jūsu vajadzībām uzlabot elektronisko datu apstrādes sistēmu. Uz to, ka šo sistēmu lietotāji bieži vien ir, un tas ir, ar to mēs lepojamies, viņi ir ļoti advancēti, viņi zina, kādas ir efektīvas un modernas sistēmas, viņi grib vēl labākas, un tas viss dzen mūs uz priekšu, lai mēs varētu savstarpēji konkurējot, savstarpēji viens otram spiežot attīstīties, tiešām iegūt pašu labāko rezultātu. Šodien ir arī jubileja, Maksātnespējas kontroles dienestam. Šo jubileju mums ir sagādājuši tās darbinieki, jūs, tos vadītāji. Un es gribētu noslēgumā teikt, ka mēs strādāsim visi kopā, gan ministrija, gan dienests, gan tiesa administrācija, jo mēs visi esam lieli savu darbu patrioti. Un es zinu, ka Maksātnespējas kontroles dienesta darbinieki savu darbu lielā mērā veids nevis balstoties uz tām algām, bet balstoties uz savu entuziasmu, uz savu apziņu, ka viņiem patīk šis darbs un ka viņi vēlas, lai ar šo darbu viņi varētu lepoties un varētu lepoties visu Latviju un varētu lepoties arī Tieslietu ministrija. Un lai šī jubilejas diena mums ir kā labs sākuma punkts nākamajiem 20 un vairāk gadiem, kad mēs varēsim ne tikai būt lepni par savu darbu, bet arī apmierināti ar savu stabilitāti, apmierināti ar saviem darba apstākļiem, un arī mūsu partneri un klienti arī būtu priecīgi apmierināti un teikt, jā, tas gāja grūti, tajā bija ielikts ļoti daudz darba, bet visas tās lietas, par ko kādreiz runāja par maksātnespējas sistēmām un dienestiem un pasākumiem, ka tās grūtības un izaicinājumi ir aiz muguras, un mēs droši skatāmies nākotnē. Paldies jums, un es noslēgumā gribētu, savas runas noslēgumā gribētu arī pateikties nedaudz redzamākā formā. Es gribētu pasniegt dienesta vadītāju Ines jums ziedus. Liels paldies jums par jūsu veikto darbu. Tas ir tā kā, lai jums labāks noskaņojums.
Liels paldies.
Paldies jums.
Paldies, ministra kungs.
Jā, un jā. Un es arī gribētu Allas kundzei arī pasniegt ziedus, jo kamēr jūsu dienests pildīja, slikts vārds pildīja, bet bija atvaļinājumā ar ļoti labiem nodomiem un iemesliem, ja? Tikmēr viss pārējais kolektīvs strādā. Mēs tā kā jūsu personā ceļam Allu gribētu arī pateikties visam kolektīvam.
Paldies.
Paldies ministram. Nu rekā, ne tikai, kas saka runa, bet arī taustāms guvums šajā jubilejas reizē. Brīnišķīgi. Paldies liels. Pirms mēs sākam konferences saturu, mums vēl viena svinīga uzruna, un jūs jau nojaušat, ka mūsu uzrunāt ir gatava Maksātnespējas kontroles dienesta direktore Inese Štēna. Lūdzu.
Labdien, cienījamās dāmas, augsti godātie kungi, klausītāji klātienē, gan arī attālināti kolēģi, nozares eksperti Latvijā un arī no tālākām zemēm. Paldies jums, ministra kungs, par apsveikumiem un atzinīgiem vārtiem. Esmu gandarīta par mūsu lielisku sadarbību ar Tieslietu ministriju un tās komandu, jo tikai ar savstarpēju atbalstu mēs esam varējuši vairākus gadus atpakaļ uzsākt digitalizācijas procesu. Un šodien novērtējam Maksātnespējas jomas digitalizācijas procesa priekšrocības. Vēlos jums visiem izteikt pateicību par dalību Maksātnespējas nozares digitalizācijas veltītajā konferencē Insolvency Goes Digital, ar ko vienlaikus atzīmējam arī Maksātnespējas kontroles dienesta 20 gadu jubileju. Augstu novērtēju ļoti lielu interesi, ko raisījusi mūsu konference, un jūsu ieinteresētība šajā pasākumā tikai vēlreiz apliecina temata aktualitāti. Konference norisināsies 2 daļās, no kurām pirmo daļu nolēmām veltīt stāstam, kā Latvijā Maksātnespēja kļuva digitāla. Maksātnespējas kontroles dienas digitalizācijas ceļu atsāk jau 2017. gadā, kad tika likti elektroniskās maksātnespējas uzskaites sistēmas, jeb EMUS pamati. Un šodien ar lepnumu var teikt, ka EMUS ir kļuvis par neaizstājumu rīku gan maksātnespējas procesa administratoriem, gan arī Maksātnespējas kontroles dienestam. Kā Tieslietu ministrs zīmīgi teica, digitāla rīku izveide prasa ievērojumu gan intelektuālu, gan arī cilvēka resursu ieguldījumu. Un tādēļ es vēlos izmantot šo brīdi, lai pateiktos tiem cilvēkiem Maksātnespējas kontroles dienestā un arī tiesu administrācijā, bez kuriem EMUS nebūtu tapis, un kuri joprojām nenogurdinoši arī ikdien strādā, lai šo sistēmu attīstītu. Un šodien mēs kopīgi novērtēsim un smelsimies arī iedvesmu nākotnes attīstībai. Savukārt otrajā daļā mēs metīsim skatu ārpus Latvijas un dzirdēsim Lietuvas, Polijas un Čehijas digitalizācijas pieredzes stāstus. Man īpaši prieks, ka mūs ar savu attālināto klātbūtni konferencē pagodinās arī Eiropas rekonstrukcijas un attīstības bankas pārstāve Katerīna Bridži-Zolēra. Un sniedzot plašāku skatījumu uz Eiropas digitalizācijas tendencēm maksātnespējas jomā. Novēlu visiem patiešām interesantu, aizraujošu un arī vērtīgu šo dienu. Esiet aktīvi, piedalieties arī diskusijās, un es esmu pārliecināta, ka dzirdētie pieredzes stāsti iedvesmos mūs tālākai maksātnespējas nozares attīstībai tieši digitalizācijas virzienā. Un ar šo es pasludinu Maksātnespējas kontroles dienesta 20 gadu jubilejas konferenci Insolvency Goes Digital par atklātu.
Paldies Šteins kundzei. Vispār mums tāda laba sadarbība. Man tik daudz bija, kas jāpastāsta, kas būs šai konferencē, bet ir izdarīts un mazāk darba. Bet jā, solās tiešām būtu ļoti labs saturs. Pirmajā daļā vairāk fokus uz Latvijas stāstu, pieredzi, un otrajā daļā vairāk tad skatīsimies, ko tad ir citās valstīs cilvēki paveikuši šajā tepat jomā. Tad sāksim, es domāju, nav ko tur diži atlikt. Pirmā runātāja būs, no organizātoru puses, no Maksātnespējas kontroles dienesta. Interesants amata, bet departamenta nosaukums. Pirmais uzraudzības departaments. Man tas liek domāt, cik tad vispār kopā tur ir tie uzraudzības departamenti. Bet to mēs uzzināsim vēlāk. Tad Agnese Barojāne ir Maksātnespējas kontroles dienesta pārstāve un runās par elektroniskā maksātnespējas uzskaits sistēmu, tās ieviešanu un kur tad mēs esam šobrīd. Man uzreiz jautāja, vai jūs lietojat savā leksikā ikdienā ar kolēģiem šo emus, kā saīsinājumu? Emīts, vai emus? Tā kā emus, ja? Labi, paldies liels.
Labdien, kolēģi, labdien, klātesošie un arī tie, kas mūs vēro attālināti. Droši vien man sevi otrais nav jāpiesaka, un mums ir 2 uzraudzības departamenti. Atbildot uz jautājumu, jāsaka, ka Latvijā maksātnespējas nozara savu digitalizācijas ceļu visticamāk uzsāka 2008. gadā ar maksātnespējas reģistra izveidošanu. Bet tāds liels un būtisks lēciens mūs sagaidīja 2019. gada 1. janvārī līdz ar elektroniskās maksātnespējas uzskaites sistēmas ieviešanu. Un šī ir pirmā reize, kad sistēmu mēs prezentējam plašākai auditorijai, tāpēc šodien es jums tā detalizētāk mēģināšu izstāstīt par to, kāda ir sistēmas rašanās vēsture, kādas ir tās funkcijas, kāda ir ieguvumi no sistēmas un arī to, kāda ir nākotnes attīstības virzieni. Tātad vēsturiski jāsaka, ka sistēma ir veidojusies kā administratoru darbības pārskatu uzskaites sistēma. Līdz 2016. gadam administratori savus darbības pārskatus iesniedza tātad brīvā formā, pārsvarā tas bija Excel formāts un nosūtīja uzraudzības iestādē, tātad Maksātnespējas kontroles dienestam e-pastā. Un no tā izrietēja tādas 2 diezgan būtiskas problēmas. Pirmkārt, ar šiem es saukšu tās par Excel tabulām, bija diezgan apgrūtinoši veikt administratoru uzraudzību, tie bija grūti izsekojami, protams, katrs to Exceli, it kā forma bija noteikta ministru kabineta noteikumos, bet katrs to Excelīti izveidoja nedaudz savādāk, un tad tā izsekošana bija diezgan apgrūtinoša. Un otra ļoti būtiskā problēma – dati, ko saturēja šie Exceli par maksātnespējas procesu, kreditoru prasījumi, izmaksas, atgūstamības rādītāji, viņi nebija apstrādājami tādā kvantitatīvā formā, ja tāda normāla statistika no šiem datiem nebija izgūstama. Uz šīm 2 problēmām norādīja gan valsts kontrole savā 2015. gada ziņojumā, gan ārvalstu investoru padomi savā pētījumā, pasakot, ka kārtīgi apstrādājami dati ir nepieciešami gan maksātnespējas procesu uzraudzībai, gan nozares rādītāju apkopošanai. Un līdz ar to 2016. gada 30. aprīlī savu darbību uzsāka pirmā elektroniskā maksātnespējas uzraudzības sistēma. Jāsaka, sistēma bija samērā vienkārša. Administratori tajā ievadīja reizi ceturksnī informāciju, ģenerēja darbības pārskatus, nosūtīja viņus kreditoriem un citām maksātnespējas procesā iesaistītajām personām. Savukārt maksātnespējas kontroles dienests šai informācijai piekļuva šajā sistēmā. Sistēmas funkcionalitāte tiešām salīdzinoši vienkārša, bet tajā jau bija vēsturiski taisītas pamata atskaites, lai mēs varētu statistiski jau iegūt datus par maksātnespējas nozari raksturojošiem pamatrādītājiem, maksātnespējas procesa izmaksām, atgūstamības rādītājiem un maksātnespējas procesa ilgumu. Taču tad līdz ar maksātnespējas politikas pamatnostādnēm tika saprasts, ka šis informācijas apjoms nebūtu nav pietiekošs un ir vajadzīgs plašāks informācijas apjoms par maksātnespējas procesu un ir jāveicina arī uzraudzība. Līdz ar to 2019. gada 1. janvārī savu darbību uzsāka elektroniskā maksātnespējas uzskaites sistēma. Droši vien turpmāk to saukšu par sistēmu vai par EMUS. Šeit jāpiemina, ka arī maksātnespējas politikas pamatnostādnēs tika norādīts, ka ir nepieciešams maksātnespējas datus padarīt publiskus plašākam sabiedrības lokam un tika uzdots izveidot sistēmu, kas datus par maksātnespējas nozari un administratoru rezultatīviem rādītājiem publicētu sabiedrībai pieejamā formātā Maksātnespējas kontroles dienesta mājaslapā. Un esošais EMUS, saucamais vecais EMUS, šādu funkcionalitāti nespēja nodrošināt, un arī tas bija iemesls, kas lika mums veidot jauno sistēmu. Tālāk, kas tad īsti ir EMUS? Pirmām kārtām jāsaka, ka tā ir valsts nozīmes informācijas sistēma. Tātad tas status, salīdzinot ar iepriekšējo sistēmu, ir daudz nozīmīgāks. Sistēmas pārziņas ir Maksātnespējas kontroles dienests, bet sistēmas turētājs ir tiesu administrācija. Sistēmas darbība regulēta normatīvajos aktos. Pirmām kārtām tas ir valsts informācijas sistēma likums, kas regulē dažādas drošības jautājumus, un otrām kārtām tas ir maksātnespējas likums, kur ir definēti sistēmas darbības mērķi, un papildus tam, protams, mums ir dažādi ministra kabineta noteikumi, kas regulē dažādas procesu sistēmā. Runājot par sistēmas darbības mērķi, tie ir nodefinēti 3. Pirmām kārtām tas ir sekmēt maksātnespējas kontroles dienestu uzdevumu izpildi, otrām kārtām sekmēt administratoru un tiesiskās aizsardzības procesu uzraugošo personu uzdevumu izpildi, un treškārt sekmēt informācijas apriti starp maksātnespējas procesā iesaistītajām personām. No minētā secīgi izriet arī EMUS lietotāju loks. Pirmām kārtām tie ir maksātnespējas kontroles dienesta nodarbinātie, otrkārt tie ir administratori un tiesiskās aizsardzības procesa uzraugošās personas, un treškārt tā ir arī plašāka sabiedrība un citas maksātnespējas procesā iesaistītās personas, piemēram, tiesa un kreditori. Runājot jau par konkrētām EMUS funkcijām, jāsaka, droši vien pirmā un būtiskākā funkcija ir EMUS ir administratoru darba vide. Un ko tas nozīmē? Tas nozīmē to, ka administratori EMUSā ved savu lietvedību, viņi reģistrē pilnīgi visus ienākošos un izdejošos dokumentus, tātad pilna maksātnespējas procesa lietas dokumentācija ir pieejama online režīmā EMUSā. No 2021. gada aprīļa administratoriem EMUSā ir ieviest arī e-adreses funkcionalitāte. Līdz ar to administratori arī caur e-adresi var nosūtīt un saņemt caur sistēmu dokumentus. Un trešām kārtām, kas ir arī ļoti būtiski, administratori sistēmā veic detalizētu uzskaitu par maksātnespējas procesu norisi. Ir pieejama informācija par kreditoriem, par maksātnespējas procesa izmaksām, par mantu, par iegūtajiem līdzekļiem, respektīvi visa informācija, ko administrators rada ar savām darbībām maksātnespējas procesā, sistēmā tiek ievadīta. Tālāk sistēma ir arī tiesiskās aizsardzības procesu uzraugošo personu lietvedības sistēma. Te gan jāsaka, ka uzraugošās personas funkcija tiesiskās aizsardzības procesā ir stipri vien ierobežotāka nekā administratoriem, līdz ar to arī sistēmā viņi ved tikai savu lietvedību. Nosūta, reģistrē nosūtītos un saņemtos dokumentus un vairāk īsti sistēmu citām funkcijām viņi nelieto. Tālāk administratoru saraksts. Maksātnespējas kontroles dienests ir tā institūcija, kas pieņem lēmumus par administratoru amata darbības jautājumiem. Tādēļ ir tikai loģiski, ka šajā sistēmā mēs uzturam arī administratoru sarakstu. Tātad administratoru sarakstā ir visa informācija gan par administratoru amata darbību, gan par viņa administrētajiem maksātnespējas procesiem, kā arī par viņa civiltiesisko apdrošināšanu un, kas arī ir ļoti būtiski, atrašanos tai saucamajā rindā, jeb administratoru pretendentu sarakstā. Kāpēc šis saraksts ir tik būtisks? Jo tālāk EMUS šo sarakstu padod tiesu informatīvajai sistēmai, kur tālāk notiek izloze maksātnespējas procesiem, par ko jums droši vien nevis droši vien, bet tālāk pastāstīs man kolēģi Karina nākamajā prezentācijā, kā arī EMUS ir tas avots, kas Maksātnespējas reģistram, uzņēmumu reģistrā nodod informāciju par administrātoru amata jautājumiem, kur savukārt šī informācija iegūst publisku ticamību. Tālāk, protams, ļoti būtisks jautājums, un sistēma patiesībā ir savu veidu atslēgu uz efektīvu maksātnespējas procesu uzraudzību, un šeit tā ir divas ļoti būtiskas lomas. Pirmām kārtām Maksātnespējas kontroles dienests ir ieviesis riskos balstītu uzraudzības sistēmu, un, lai varētu īstenot riskos balstītu uzraudzību, mums ir nepieciešams ļoti būtisks informācijas apjoms un kvantitatīvi apstrādājumā veidā. To sistēma mums ļauj darīt. Un otra funkcija, ko EMUS pilda uzraudzības jautājumos, ir jau manis minētā administrātora lietvedība, administrātora ievadītā informācija par maksātnespējas procesu, jo līdz ar to Maksātnespējas kontroles dienests šai informācijai piekļūst sistēmā, un tas ir ļāvis neklātienes uzraudzību pacelt tādā līmenī, ka principā mums administrātori paši iesaist uzraudzības lietās ir vajadzīga, lai jau noskaidrotu viņa rīcības motīvus un paskaidrojumus. Visu uzraudzības informāciju, kas ir saistīta ar viņu dokumentu izpēti, ar informāciju par procesu, mēs iegūstam online režīmā, un tas mums ir ļāvis tiešām neklātienes uzraudzībā spērt ļoti būtisku soli uz priekšu. Tālāk publicējumā informācija, es jau minēju, ka ar Maksātnespējas politikas pamatnostādnēm tika uzdots publicēt zināmu informāciju visai sabiedrībai pieejamā veidā. Līdz ar to caur šo sistēmā šobrīd uzkrāto informāciju sabiedrība Maksātnespējas kontroles dienesta mājaslapā var redzēt diezgan visaptverošu informāciju par administrātoru rezultatīvajiem rādītājiem. Tie ir gan viņa pārkāpumi, gan viņa administrāto procesu rezultatīvie rādītāji, gan administrāto procesu skaits, respektīvi, ja sabiedrībai ir interese, šī informācija viss ir publiski pieejama. Jā, tālāk darbinieku prasījumi. Maksātnespējas kontroles dienests ir tā iestāde, kas administrē arī darbinieku prasījumu garantiju fondu. Un jāsaka, ka šis process ir ārkārtīgi laikietilpīgs un viņš ir ļoti sarežģīts. Darbinieku prasījumu sekšanai apakšā ir milzīgi aprēķini un tāds pamatīgs administratīvais process. Un viens no tiem mērķiem EMUS ieviešot noteikti bija arī digitalizēt un padarīt iestādes resursu mazāk aizņemošu šo darbinieku prasījumu administrēšanu. Šobrīd darbinieku prasījumu kalkulācijas arī notiek EMUSā. Protams, e-pakalpojums. Runājot par digitalizāciju, ir skaidrs, ka digitāla vide ir tāda, kas ir digitāli pieejama plašākai sabiedrībai un plašākai procesā iesaistīto personu grupai. Šajā sakarā mēs esam izveidojuši sistēmai arī e-pakalpojumu. E-pakalpojums nozīmē to, ka jebkurš kreditors savu kreditoru prasījumu maksātnespējas procesā administrātoram var iesniegt pa taisno sistēmā. Ar drošiem rīkiem ielogojoties sistēmā, iesniedz kreditoru prasījumu, administrators viņu savā galā apstrādā. Papildus e-pakalpojumā jebkuram kreditoram ir pieejama daudz plašāka informācija par maksātnespējas procesu, nekā tas ir administrātoru darbības pārskatos. Un šī informācija ir pieejama arī daudz regulārāk. Ja man administrators šodien ir padarījis pieejamu kādu dokumentu sistēmā, es šodien ieeju e-pakalpojumā un to dokumentu arī redzu. Es redzu daudz izvērstākas maksātnespējas procesa izmaksu pozīcijas, respektīvi tas informācijas loks, ko kreditors var izmantot savu interešu aizstāvībai, ir daudz plašāks. Pēdējais un droši vien visbūtiskākais un man pašai visnozīmīgākais ir dati. Un par datiem es gribētu parunāt nedaudz plašāk, jo arī ministrs jau pieskārās statistikas un datu tēmai, un tā nenoliedzami ir ārkārtīgi būtiska. Uz datu nozīmi ir norādījusi gan valsts kontrole, manis pieminētā, arī starptautiskais valūtas fonds savās rekomendācijās ir paudis to, cik lielai nozīmē ir datu kvalitātei un pieejamam datu apjomam par nozarē notiekošo, jo principā bez kvalitatīvas datu analīzes nav iespējams pieņemt ne kvalitatīvus lēmumus likumdošanas procesā, ne izdarīt adekvātus secinājumus par to, kas nozarē patiesībā notiek. Un jāsaka, ka šajā sakarā EMUS ir tiešām unikāla informācijas sistēma, jo mums valstī maksātnespējas process ir sadalīts starp dažādām institūcijām, kurai katrai ir kaut kāda informācijas druska par maksātnespējas procesu. Maksātnespējas process sākas tiesā, līdz ar to starta informācija par to ir tiesu informatīvajā sistēmā par lietas ierosināšanu un tālākiem tiesas lēmumiem. Publiskās ticamības fakti tiek reģistrēti maksātnespējas reģistrā. Dati par pašu maksātnespējas procesu norisi ir administratori radīti, tie ir pie administratori, manis jau pieminētie kreditoru prasījumi, procesa izmaksas, atgūtie līdzekļi. Un dati par maksātnespējas procesa administratoru uzraudzības rezultātiem ir Maksātnespējas kontroles dienestā. Un tad EMUS ir tā platforma, kurā visi šie datu avoti tiek salikti kopā, principā veidojot unikālu lietu un informācijas apjomu par visa maksātnespējas procesa norisi. Un jāsaka, ka mums ir arī citas informācijas sistēmas, mums ir kontu reģistrs EMUSā pieslēgts un arī CSDD datubāze. Un no šiem datiem mums veidojās tāda pilna maksātnespējas procesa aina, pieejama ar dažu klikšķu palīdzību. Un kāpēc tas ir tik nozīmīgi? Manis jau pieminētā riskos balstītā uzraudzība. Lai mēs tiešām runātu par riskos balstītu uzraudzību, mums ir jārunā par ļoti lielu informācijas apjomu, kas spēj identificēt riskus un ieraudzīt, kur ir tie riska momenti. Un EMUS ir tā sistēma, kas mums šobrīd ar šo informācijas apjomu tiešām šo informāciju ļauj apstrādāt un atrast riskus un savu uzraudzības sistēmu balstīt uz viņiem. Otrs ir, protams, objektīva situācijas novērtēšana nozarē. Mēs varam redzēt dažādus datus diezgan dinamiski par to, kā virzās maksātnespējas nozara, kurā virzienā. Šobrīd ļoti aktuālais, vairs ne tik ļoti varbūt, bet cerams arī nebūs aktuāls, maksātnespējas lietu skaita pieaugums Covid-19 sakarā. Mums ļāva, piemēram, monitorēt tādu jautājumu, kā maksātnespējas lietu ierosināšana tiesā, maksātnespējas procesu pasludināšana, lai saprastu, kāda tad ir tā dinamika, cik daudz kreditoru aktivitātes tajā visā ir, lai saprastu, vai mums laicīgi nav jārēģē ar kādiem likumdošanas iniciatīvas jautājumiem. Jā, tā tad objektīvi novērtēta nozare, analīze par jautājumiem atsevišķiem un riskos balstīta uzraudzība. Tie ir viennozīmīgi tādi ieguvumi, kas līdz sistēmas izveidošanai mūsu rīcībā nebija. Es skatos, ka man nav vairs baigi daudz laika, bet īsumā izstāstīšu arī par dažām lietām, kas ir mainījušās līdz ar EMUS ieviešanu. Pirmkārt, tā ir kreditoru prasījuma iesniegšana. Es jau pieskāros, ka šobrīd mums ir izveidots e-pakalpojums. Līdz tam administratoram kreditoru prasījums bija iesniedzams e-pastā vai pa pastu vai klātienē. Administrators šo te prasījumu izskatīja un manuāli sastādīja kreditoru prasījumu reģistru. Iesniegšanas kārtība šobrīd arī vecā nav atcelta. Klāt ir nācis tas, ka kreditoru prasījums ir iesniedzams caur e-pakalpojumu, un kas būtiski šobrīd administrators to informāciju EMUSā ievadot ar vienu klikšķi ģenerē kreditoru prasījumu reģistru. Viņam nav jātaisa manuāli nekādas tabulas šobrīd. Darbinieku prasījumu izskatīšana, arī to jau es pieminēju, tātad smagnējs administratīvs process, pirms tam visi aprēķini notiek manuāli, manuāli tiek sagatavoti lēmumi, šobrīd aprēķini notiek sistēma automātiski un sistēma spēja arī ģenerēt jau lēmumus par darbinieku prasījumu sekšanu. Lietvedība, arī to jau es minēju pirms tam, pirms šīs sistēmas ieviešanas katram administratoram bija sava lietvedības uzskaitas sistēma, un visbiežāk tā bija Excel tabula, kurā tika reģistrēti visi ienākošie izējošie dokumenti. Šobrīd tā ir valsts nozīmes informācijas sistēma, kurā šie dokumenti tiek reģistrēti. Papildus tam mums ir arī e-adrese, caur kuru administrators tātad var sūtīt un saņemt dokumentus. Un administratoru darbības pārskata arī tiem jau es pieskāros līdz sistēmas ieviešanai. Administratoru darbības pārskata tātad bija reizi ceturksnī. Administrators pats tātad ievadīja šīs summas un tālāk ģenerēja pārskatu, ko nosūtīja procesā iesaistītajām personām. Šobrīd sistēma ir mainījusies pilnībā. Administratoru darbības pārskati tiek ģenerēti reizi mēnesī. Tātad 3 reizes biežāk nekā līdz šim. Ja. Un administrators ar savām aktīvām darbībām šo darbības pārskatu vairs nekādā veidā neģenerē. Viņš regulāri ievada EMUSā visu informāciju par maksātnespējas procesu un sistēma pati reizi mēnesī ģenerē darbības pārskatu un nosūta to visām procesā iesaistītajām personām. Un automātiski, protams, šo dokumentu piereģistrē arī administratoru lietvedībā. Vēlreiz īsi par ieguvumiem. Administratoriem tā noteikti ir lietvedības sistēma un e-adrese, un kāpēc es visu laiku uzsveru to e-adresi, jo pretējā gadījumā, ja e-adrese nebūtu ieviesta sistēmā, e-adreses izmantošanai administratoriem būtu jāmeklē citi risinājumi, un tas būtu ļoti laikietilpīgs un administratīvi diezgan sarežģīts process. Saslēgumi ar citām informācijas sistēmām, manis jau pieminētā CSDD datubāze, kurā ir pieejama informācija par parādnieku transporta līdzekļiem, un noteikti arī kontu reģistru gribētu uzsvērt. Kontu reģistrs ir tā informācijas sistēma, kurā ir pieejami dati par parādnieku norēķinu kontiem. Un tikai un vienīgi caur saslēgumu ar EMUS administrators šai informācijai no šīs informācijas sistēmas var piekļūt. Atvieglota darbinieku prasījumu iesniegšana, dokumentu ģenerēšana, tie visi ir administratori ieguvumi no sistēmas, ko es jau minēju. Maksātnespējas kontroles dienesta un valsts ieguvumi noteikti ir manis minētā uzraudzība, digitalizētā darbinieku prasījuma izskatīšana, nozares datu pieejamība un visai sabiedrībai kopumā tā ir daudz lielāka maksātnespējas procesa atklātība. Runājot par kreditoru grupu, noteikti elektroniska prasījuma iesniegšana un daudz plašāks informācijas apjoms. Nedaudz par EMUS aktivitātēm. Lietvedībā kopumā šobrīd jau mums ir reģistrēts 500 000 ar dokumentiem no 2019. gada 1. janvāra. Sistēmā kopumā ir dati par 32 000 maksātnespējas procesu un tiesiskās aizsardzības procesu. Te gan uzreiz jāuzsver, ka par vēsturiskajiem maksātnespējas procesiem tas datu apjoms ir stipri ierobežotāks nekā šobrīd. EMUS lietotāju skaits, ar to domājot, Maksātnespējas kontroles dienesta administrators un tap uzraugošās personas ir 247, un EMUS e-pakalpojumu lietotāju skaits, tātad kreditori pārsvarā, šogad jau ir 3058. Protams, par attīstību, neskatoties uz to, ka sistēma arī ikdienā prasa daudz dažādas pielāgojumus un ieguldījumus, mēs esam arī domājuši par tādu lielāku sistēmas attīstību, jo sistēmai noteikti ir milzīgs attīstības potenciāls. Un tie 3 attīstības virzieni, par ko mēs esam domājuši, ko mēs esam izplānojuši un ko mēs esam arī iekļaujuši dažādos attīstības dokumentos, ir datu apjoms un kvalitāte, automatizēta uzraudzības rīki un lietotājiem draudzīga sistēma un digitāla risinājumi. Par datu apjomu un kvalitāti jau minēju, cik datu pieejamība sistēmā ir svarīga, taču ir ārkārtīgi būtiski, lai dati sistēmā būtu arī precīzi un patiesi. Un datu precizitāti un patiesumu mēs varam iegūt ar saslēgumiem ar citām informācijas sistēmām, jeb respektīvi informācijas izgūšanu no informācijas pirmavota. Ja mums, piemēram, parādniekam zemesgrāmatā ir nekustamais īpašums, tad ir skaidrs, ka informāciju par šo nekustamo īpašumu visprecīzāk mēs varam iegūt pa taisno no zemesgrāmatas. Līdz ar to datu kvalitāte ir tas jautājums, kāpēc mēs, protams, ļoti sapņojam par papildus informācijas saslēgumiem, un arī datu apjoms ir tas jautājums, kas ir ļoti būtisks. Un šeit es tiešām vairāk domāju par valsts ieņēmumu dienesta rīcībā esošo informāciju, kas satur datus par parādnieka komercdarbību līdz maksātnespējas procesam. Tas ir apgrozījums, tas ir komercdarbības veids un tā tālāk. Un kāpēc tas ir tik būtiski? Jo šobrīd, skatoties maksātnespējas datus, mēs nedaudz atrauti lūkojamies uz viņiem no iepriekšējās komersanta darbības. Lai mēs iegūtu informāciju par to, cik mums šobrīd esošie maksātnespējīgie parādnieki, kurās nozarēs ir strādājuši, mums ir jāveic diezgan pamatīgs manuāls darbs šo informāciju vienkārši manuāli apkopojot un saliekot pretī tiem parādniekiem. Tas, ko mums ļautu darīt piekļuve jau šai valsts ieņēmuma dienestas informācijai, ir skatīt maksātnespējas nozari kontekstā ar uzņēmēju darbību kā tādu nozares, uzņēmumu apmērs, apgrozījumu, un tas ir ļoti būtiski gan novērtējot nozari kopumā un uzņēmēju darbības vidi, gan, protams, runājot arī par riskos balstītas uzraudzības sistēmas attīstīšanu. Tātad datu kvalitāte un manis jau iepriekš pieminētie datu izmantošanas bonusi, tas viss ir tas, par ko mums ir jādomā arī nākotnē. Automatizēta uzraudzības rīki, atsaucoties arī uz ministra kunga teikto, ka cilvēkiem ir jādara lietas, kurās ir vajadzīga cilvēka intelektuāla iesaiste. Arī par to domājot, mēs vēlamies sistēmā attīstīt automatizētas uzraudzības rīkus, kas ļautu sistēmai pašai atrast dažādus riska faktorus, datu anomālijas un savukārt Maksātnespējas kontroles dienesta cilvēku resursus jau varētu strādāt jau ar reālām uzraudzības lietām un šo datu, tā teikt, analīzi, kur ir vajadzīgs cilvēka intelektuālais resurss. Tas, protams, arī ļautu mums uzlabot datu kvalitāti sistēmā, par ko ir sevišķi jādomā. Un lietotājiem draudzīga sistēma digitāla risinājuma. Mēs, protams, saprotam, ka, lai lietotājs gribētu sistēmu lietot, tai ir jābūt ļoti ērtai, draudzīgai un ar bonusiem. Pretējā gadījumā tā ir tāda cīņa par to, lai sistēma tiktu lietota. Un šajā sakarā mēs esam ieplānojuši arī daudzus vienkārši ērtuma uzlabojums un esam ieplānojuši sistēmā pieejamos datus, publicēt arī atvērto datu portālā, kas Maksātnespējas nozares datus padarītu pieejams vēl plašākai sabiedrībai. Ņemot vērā to, ka es jau teicu, ka šī ir pirmā reize, kad sistēma tiek prezentēta plašākam lokam, un man laikam ir arī kāda minūte laiks vēl, tad es tiešām gribētu pateikt lielu paldies Maksātnespējas kontroles dienesta kolēģiem par iesaisti sistēmas izveidē un arī uzturēšanā, jo tas ir ļoti smags darbs. Es gribētu pateikt paldies arī Maksātnespējas procesa administratoriem, kuri sistēmu lieto un regulāri sniedz arī ļoti noderīgus priekšlikumus sistēmas uzlabošanā. Pateikt paldies arī Tieslietu ministrijas kolēģiem par atbalstu sistēmas izveidošanā un uzturēšanā, bet vislielākais paldies man šodien droši vien ir jāsaka tiesu administrācijas kolēģiem, kuri ir bijuši ar mums kopā no pašas sistēmas izveidošanas dienas un arī šobrīd ikdienā strādā ar mums plec pie plec ar sistēmas uzturēšanas jautājumiem. Tā kā paldies par uzmanību. Ja ir kādi jautājumi, es labprāt mēģināšu uz tiem atbildēt.
Jā, paldies. Paldies, Agnesei. Kaut kā sadalīsim to skatuvu, ne? Tā, bet tālu neejiet, lai tie mikrofoni noķer. Paldies tiem, kas sūta jautājums. Tāds vispārīgs jautājums varbūt sākumā. Kā bija vispār? Būvēt to sistēmu. Tas jau nav viegls uzdevums.
Man liekam jārunā to.
Jā,
uzdevums noteikti nav vienkārši arī ņemot vērā to, ka pieredzes iestādē ar šādas nozīmes informācijas sistēmām mums nebija. Uzdevums noteikti nebija viegls, un es domāju, ka mēs šodien esam arī ļoti daudz mācījušies par to, ko mēs iespējams darītu savādāk, un savādāk un labāk.
Jā, man liekas, tādās sistēmās liela māksla sataisīt pareizi visu to specifikāciju, ko tu īsti gribi, lai pēc tam izpildītājs var uzprogrammēt, vai ne?
Jā, tā ir ļoti liela māksla, un jāsaka, tas ir arī jautājums, ar kuru mēs turpinam attīstīties vēl šodien, bet tieši tā mēs iestādē esam pārsvarā cilvēki ar juridisko izglītību, un runāt ar IT cilvēkiem vienā valodā ir ārkārtīgi grūti.
Jā, tad tur varbūt tulku reizēm vajag pa vidu. Labi, ko jūs darītu citādi šodien ar šodienas acīm raugoties retrospektīvi uz šo procesu?
Šodienas acīm raugoties, mēs noteikti to kumosu nekostu tik lielu uzreiz. Mēs viņu noteikti sadalītu pa mazākiem gabaliņiem, jo tas darba lauks, kas bija jāaptver, bija ārkārtīgi liels. Bet mēs, protams, esam ļoti gandarīti par paveikto un, protams, sistēma, tāpat kā Rīga, droši vien nekad nebūs gatava, bet tas rezultāts ir labs. Un vēl no tādas tīri praktiskas lietas, kas ir jāsaka, mēs droši vien nedomātu par to, ka mums visu tik ļoti vajag ar automatizētiem procesiem, jo maksātnespējas process ir tik samērā sarežģīts ar daudzām dažādām niansēm, ka tā automātika sistēmai dažreiz patraucē saprast patiesību.
Tas man atgādina automašīnas kaut kāds moderns, kur likvidē podziņu, kur tu var noregulēt temperatūru un uztaisīt to displejā. Un tu tur brauc un tu daudz vairāk patiesībā tērē laiku, lai tur ieregulētu to. Tā var vienkārši
tieši ļoti līdzīgi arī.
Jā. Labi, reka mums nāk no skatītājiem jautājumi. Paldies, ka sūtat un iedrošina to darīt arvien vairāk. Te tāds specifisks, vai varbūt tas vairāk bija izstrādātājiem par tieši to kodu rakstīšanu. Tur bija tāda koda intensīva lieta, vai tas bija vairāk tā kā tas low code, no code, tāda pieeja, ja jūs nezināsiet šo?
Es droši vien nebūšu kompetenti atbildēt uz šādiem jautājumiem.
Ne pēc adreses ienāca. Bet te gan viens, tad vai emus ir stāv aiz tā, kas ir publiski redzams Latvijas maksātnespējas reģistrs? Tātad vai šīs lietas ir saistītas?
Šīs lietas noteikti ir saistītas, vai maksātnespējas reģistrs stāv pa priekšu emusam, jeb otrādāk nosacīti. Emusā ir pilnīgi visi dati, kas ir maksātnespējas reģistrā, un maksātnespējas reģistrs daļu no datiem iegūst no emus. Šīs sistēmas tiešām ir ļoti saistītas.
Ok, tad tas bija arī jautājums. Kaut kas vēl tāds varbūt tiem, kas šobrīd apsver savās organizācijās būvēt kaut ko digitāli, varbūt vienkārši nedariet manuāls rulā.
Noteikti dariet. Es domāju, ka tas ir mums iestādes viens no lielākajiem sasniegumiem, un ne par velti šī konference ir ar šādu nosaukumu, jo mēs tiešām ļoti, ļoti lepojamies ar sistēmu.
Forši. Paldies. Paldies, Agnesei. Iedarētos aplausi, man liekas. Mēs neesam daudz šeit klātienē, bet tomēr. Paldies. Paldies. Es te lasu to nākamo pieteikumu, tā domāju par maksātnespējas procesu, kā neprofesionāls. Un par to, kā tur tie administratori tiek iecelti, te gan interesants termins ieteikti un iecelti. Par to arī nākamajā prezentācijā, par administratoru ieteikšanu, par iecelšanu konkrētos maksātnespējas procesos. Un tajā visā var redzēt, kā miedarbojas divas nozīmīgas sistēmas jau iztirzātā emus, tātad elektroniskā maksātnespējas uzskaita sistēma, un arī tiesu informatīvā sistēma, kā tās savstarpēji miedarbojas. Un te jāvērš uzmanība uz to, ka administratora ieteikšana notiek automatizēta, bet par to sīkāk izstāstīs mums Maksātnespējas kontroles dienesta juridiskā departamenta direktora Karina Paturske, kuras departamenta atbildībā arī ir šī administratora pretendentu sārakstā vešana, uzturēšana. Es skatos viņai rokā dzeltenu mapīti, iespējams, ka tas ir administratora saraksts. Skatīsimies. Lūdzu.
Labdien, cienījamie klausītāji, gan šeit klātienē, gan attālināti, bet nē, Oskar, tas nav administratora saraksts, jo arī tas mums ir digitāls. Neslēpsim, ka brīdis, kad administrators tiek ieteikts maksātnespējas procesā, ir ārkārtīgi sensitīvs. Es teiktu, tas ir viens no sensitīvākajiem brīžiem vispār visā procesā, tāpēc tam nevelti allaži ir tikusi pievērsta pastiprināta uzmanība, pārbaudot, vai viss tik tiešām notiek korekti un nav nekādu šaubu, ka pēc tieši šim administratoram tika tieši šis process. Un kāpēc mēs šodien izvilkām šo te nelielo mazo emus daļu? Jums pastāstīt, jo, manuprāt, šī te administratoru ieteikšanas procedūras attīstība ļoti lieliski mums parāda, kā digitālie rīki var palīdzēt procesu padarīt caurskatāmu, efektīvu un neitrālu. Un pie šiem vārdiem mēs vēl atgriezīsimies prezentācijas laikā, bet tagad es gribētu vērst jūsu skatu pagātnē, kā tad šī rinda ir attīstījusies, lai mēs vēl labāk spētu novērtēt, kā tad viņa mums izskatās šobrīd. Tātad, pirmā daļai automatizētā administratora ieteikšanas procedūra Maksātnespējas kontroles dienestā tika izveidota jau 2008. gadā, un saraksts tika turēts Maksātnespējas administrācijas tīmekļa vietnē. Tā teikt, izmantojot tolaik jau pieejamos tehniskos resursus. Sākotnēji tika uzturēti 5 administratoru saraksti, atbilstoši katras apgabala tiesas teritorijai. Un tātad katru darba dienu šie administratoru saraksti tika savietoti kopā ar maksātnespējīgajiem subjektiem, kas savukārt tika kārtoti alfabētiskā secībā. Un viss šis ieteikšanas process bija publiski pieejams un redzams mūsu mājaslapā. Tālākos gados jau mēs savus spēkus veltījām tam, lai stiprinātu šo te nejaušības principu rindas darbībā. Proti 2013. gadā visi administratori tika savietoti vienā administratoru sarakstā, nejaušā secībā, un arī administrēšanai vakantie subjekti tika kārtoti nejaušā secībā. Un šis administratoru saraksts tika sajaukts reizi gadā. 17. gadā jau mēs gājām solīti tālāk, un administratoru saraksts tika sajaukts jau reizi ceturksnī, Bet mēs atgriezāmies pie tā, ka vakantos subjektus mēs kārtojam atkal alfabēta secībā, tādējādi nodrošinot lielāku izsekojamību rindas darbībai. Kā jūs redzat no vēstures, mēs jau 8. gadā sākām pielikt kaut kādu automātiku šim procesam, un vienmēr šajā procesā bija klātesoši 2 spēlētāji. Mēs Maksātnespējas kontroles dienesta kā administrātoru saraksta turētāji, un otra puse bija tiesa, kas mums sniedz informāciju par šiem te vakantajiem subjektiem. Un 19. gadā tad šis process piedzīvoja, es teiktu, vienas no savām būtiskākajām pārmaiņām, kad uz skatuves uznāca jau Agneses tik plaši aprakstīta elektroniskā maksātnespējas uzskaites sistēma, jeb EMUS. Tātad turpmāk administrātora amata kandidāta ieteikšana konkrētam maksātnespējas procesam notiek izmantojot 2 sistēmu, EMUS un tiesa informatīvās sistēmas, jeb TIS, automatizētu sasaisti. Un tad no šī brīža arī Maksātnespējas kontroles dienests kā EMUS pārzinis un tiesu administrācija kā tiesu informatīvās sistēmas, jeb TIS pārzinis, uzsāka tādu ciešu sadarbību. Tad par šo te automatizēto sasaisti un procesu jums šodien izstāstīšu mazliet sīkāk. Kā tas notiek? Šeit slaidā jūs redzat, es mēģināju vizuāli tā vienkāršot šo te procesu, tā teikt, atspoguļot. Pavisam vienkārši, tātad EMUS pusē mums tiek izveidots administrātoru pretendentu saraksts. Savukārt šī te automatizētā atlase, kad administrators jau tiek ieteikts pielikts pie konkrēta maksātnespējas procesa, to nodrošina TIS. Administratoru pretendentu saraksts tiek izveidots no tiem administratoriem, kas ir izteikuši vēlmi šajā sarakstā būt. Tātad viņi ir izteikuši vēlmi, kad viņi vēlas administrēt fiziskās personas un juridiskās personas maksātnespējas procesu. Un uz viņiem neatiec nekāda veida ierobežojumi, kas ir saistīti ar viņu amata darbību. Proti, viņi nav neatstādināti no amata, ne viņu amata darbība ir apturēta. Kā tas notiek praktiski? Ļoti vienkārši administrators vēršas ar iesniegumu Maksātnespējas kontroles dienestā, tad atbildīgais darbinieks nākamajā darba dienā, ne dienu agrāk, ne dienu vēlāk, viņu ievieto EMUSā administratoru sarakstā. Un pretendentu saraksts netiek publicēts, bet vienlaikus pats administrators var iet elektroniskajā maksātnespējas uzskaites sistēmā, un viņš redzēs, vai viņš ir vai nav iekļauts rindā. Tādējādi viņš var pārbaudīt, ka tiešām Maksātnespējas kontroles dienests savu pienākumu ir izpildījis godprātīgi īstajā dienā, īstajā brīdī, un viņu rindā ir ievietojis. Tālāk jau mēs plūstoši pārējām pie TIS puses. Un tātad TIS pusē ir šīs divas plūsmas, fiziskās personas maksātnespējas procesa plūsma un juridiskās personas maksātnespējas procesa plūsma. Kad administrators tiek ievietots sarakstā, viņš aiziet uz abām plūsmām. Proti, administratoram nav iespēja izvēlēties, ka viņš vēlas administrēt tikai fiziskās personas maksātnespējas procesu vai tikai juridiskās personas maksātnespējas procesu. Viņš ir vai nu abos sarakstos, vai nevienā. Un savukārt, ja administrators tiek izslēgts no saraksta, tad viņš tiek uzreiz izslēgts no abām plūsmām. Šobrīd administratoru atlasē netiek veikta nekāda gradācija, piemēram, atkarībā no viņa profesionālās pieredzes, jo mēs prezumējam, ka brīdī, kad administrators ir iecelts amatā, viņam ir pietiekama kompetence, lai administrētu jebkuru fiziskās vai juridiskās personas maksātnespējas procesu. Šo administratoru izvēli inicijē tiesa, izmantojot tiesu informatīvo sistēmu, un tiesnesis attiecīgi arī TISā apstiprina izvēlēto administratora amata kandidātu. Tagad pāris būtiskas lietas, kas attiecas tieši šo te automatizēto atlasi, kas neslēpsim, protams, ir svarīgākā šī te rindas daļa. Mums pašiem ļoti patīk to salīdzināt ar groziņiem, tāpēc arī es izmantošu šo analoģiju stāstot par rindu. Tātad princips ir tāds, ka administrators, kurš iekļauts pretendentu sarakstā, uzsāks dalību automatizētajā administratoru amata kandidātu izvēlē pēc tam, kad visi iepriekšējā reizē TISam nodotie administratoru pretendentu sarakstā tiks izvēlēti konkrētam maksātnespējas procesam. Proti, tagad atkal iedomājamies šos te groziņus. Mums ir groziņš, kurā ir iebiruši administratori no pretendentu saraksta. Viņi šajā no te groziņa iziet ārā, viņi tiek ieteikti konkrētam maksātnespējas procesam. Un jauni administratori iebirst tajā groziņā tikai tad, kad pēdējais administrators no tā iepriekšējā groziņa būs izvēlēts maksātnespējas procesam. Un tas nozīmē arī, praktiski nozīmē, ka ja jūs, piemēram, iestājaties rindā šodien kā administrators, tas nebūtu nenozīmē, ka jūs rītdien piedalīsieties automatizētajā atlasē. Tas var tā būt, var tā nebūt, jo ir jāgaida, kamēr šis te groziņš iztukšosies. Savukārt jau dziļāk ejot iekšā šajā groziņā, tajā brīdī, kad administrators tiek iecelts jau konkrētam procesam, viņš arī no šī te groziņa, tā teikt, iet ārā konkrētajā plūsmā, un viņš paliek tādā tā kā gaidīšanas zonā režīmā, un viņš atkal tajā groziņā nokļūs, ja viņš būs aktuālajā pretendentu sarakstā, tajā brīdī, ka groziņš būs iztukšojies. Tepat te arī svarīgi atgādināt, ko jau es iepriekš minēju, kad ja administrators ir, tā teikt, ja viņš ir izslēgts no rindas, nozīmē, ka vai viņš pats ir izteicis šādu vēlmi vairs nebūt rindā, vai uz viņu attiecas kādi ierobežojumi, kas attiecas uz viņu amatu, tad šajā brīdī viņš no šiem te groziņiem gan nekavējoties tiek izņemts ārā. Te gan nenotiek nekāda kavēšanās. Un tālāk, tad, lai par šo procesu, tā teikt, runātu visaptverošāk, es esmu definējusi 4 pamatprincipus, uz kuriem mūsu rindas darbība ir balstīta, un ko mēs arī ņēmām vērā šo visu procedūru izveidojot. Pirmais ir, protams, nejaušības princips. Administratora amata kandidāta izvēle konkrētam maksātnespējas procesam notiek absolūti nejauši, un šī nejaušība tiek nodrošināta ar TIS iestrādāta algoritma palīdzību. Otrais princips ir proporcionalitāte, un tas tiek panākts ar to, kad, kā jau es minēju, administrators tiek iekļauts abās maksātnespējas procesu plūsmās, gan fiziskās, gan juridiskās personas plūsmā, tādējādi nodrošinot, kad administratoriem tiek, tā teikt, tiek izlīdzināts šo te maksātnespējas procesu skaits un nodrošinot, kad viņiem arī veidojas tāda vienmērīga un visaptveroša profesionālā pieredze. Tālāk ir, protams, tik būtiskā rindas darbībā caurskatāmība, un tā tiek nodrošināta vairākos veidos. Vispirms jau visvienkāršākais veids, tā kā process notiek sistēmās, valsts nozīmes informācijas sistēmās, tad par katru darbību ir pieejama auditācijas pieraksti. Mēs varam pārbaudīt, kurš kurā brīdī ko ir izdarījis, un vai tiešām tas ir noticis atbilstoši normatīvu aktu prasībām. Tāpat mēs arī veicam regulārus neatkarīgus auditus, kur tad šie auditācijas pieraksti arī neatkarīgi vērtētāju auditoru skatījumā tiek skatīti un pārbaudīti, vai tik tiešām viss ir noticis tā, kā tam bija jānotiek, un vai nav notikusi kāda pretiesiska iejaukšanās šajā procesā. Vēl papildus Maksātnespējas kontroles dienests arī post factum, kad šis te administratora groziņš ir iztukšojies, mēs publicējam noslēgušās rindas sarakstu, lai arī paši administratori var pārliecināties, ka attiecībā uz viņiem ir ievērotas visas normatīvu aktu prasības un rinda ir nostrādājusi tā, kā tai būtu jānostrādā. Un ceturtkārt, kā pēdējo no principiem vēlos minēt neutralitāti, ko šī te automatizētā sasaiste mums nodrošina. Un tā ir viena no lielākajām atšķirībām no iepriekšējām sistēmām, kad nevienam nav pieejams tādā tiešsaistes režīmā skatījums, kas tad notiek ar šo te rindu. Un te arī pieslēdzās jau minētais caurskatāmība, kad ar šie te auditiem mēs mazinam šo te risku, ka tā rinda nav redzama, jo tomēr mēs pēc kaut kāda laika pārbaudam, ka tiešām viss noticis ir korekti. Un kas vēl neutralitāte izpaužas arī šajā te automatizācijā, tādā veidā, ka tiek novērstas pavisam cilvēcisku kļūdu rašanās, un arī, protams, tiek novērsta kaut kāda iespējama ieinteresētība no iesaistīto nodarbināto vidus. Tā kā kopumā, manuprāt, mums ir izdevies radīt tādu sistēmu, pateicoties mūsu abu sistēmu sadraudzībai, kas tiešām nodrošina to, kad maksātnespējas procesā administrātora ieteikšana tiek nodrošināta efektīvi, neitrāli un caurskatāmi. Un tik tiešām pēdējos gados es varu teikt, ka nav vairs publiskajā telpā bijuši aktualizēti jautājumi vai šaubas par rindas darbības korektumu. Tā kā es teiktu, ka mēs esam savu mērķi ar šo rindu ļoti labi sasnieguši. Paldies!
Nu, re. Pēc prezentācijas tā sajūta vienmēr ir labāka nekā pirms, vai ne?
Daudz labāk, jā.
Tas ir tā interesanti. Ir gandarījums.
Jā,
sanāca, kā plānots.
Gandrīz, jā.
Dēls Karnegi, viņš bija tāds slavens pagājušā gadsimta amerikāņu lektors un arī publiskās runas pasniedzējs. Viņš teica, ka vienmēr būs 3 runas. Viena, kur tu plānoji, viena, kur tu pateici, un viena, kur tu būtu gribējis pateikt. Un šīs 3 runas vienmēr atšķiras, tā kā tur viss kārtībā. Viņš arī, starp citu, Warren Buffett ir trenējis publiskajā runā. Tāds vīrs bija. Nu labi, paskatāmies, ko mēs te varam par nākotni parunāt. Es redzēju tur to grafiku, tur pa gadiem, kāds viss attīstījās, un groziņš ļoti smuks, starp citu, bija tā, varēja labi saprast. Bet kas tālāk? Vai tur ir vēl attīstības iespējas? Ir kaut kādas tādas, ka šitais vēl labi nestrādā un te vajadzētu uzlabot?
Jā, mēs, protams, saredzam attīstības iespējas. Es minēju prezentācijā, ka mums šobrīd nav šī administratoru gradācija nekādā veidā rindā. Uz nākotnes skatoties, mēs redzam iezīmes, ka varbūt kaut kāda gradācija varētu tikt ieviesta. Mums ir arī, piemēram, atsevišķa procesu veidi kredītiestādes maksātnespējas procesu, kur administratoram ir pilnīgi citas prasības, augstākas. Līdz ar to, ja mēs iekļautu arī šo procesu šajā automatizētajā rindā, tad skaidrs, ka šeit nāktu klāt, ka viņam būtu prasības par konkrētu kvalifikāciju, profesionālo pieredzi un tam līdzīgi. Tas ir tas skats uz nākotni.
Tad tie kritēriji gradācijai varētu būt specifiski nišas kaut kāda administratora, kā jūs minējat, piemēram, kas specializēs uz banku likvidāciju.
Jā, tas, piemēram, būtu, ja banku maksātnespēja runājam, tad tas, piemēram, būtu šās te AML certifikāts. Tur bankas pašas ir un arī Finanšu ministrija ir akcentējis, ka tas būtu tā kā prasība administratoriem.
Redz, jā, tas ir citi jautājums ienāca kas interesanti, jautājumi nāk angliski. Vai es varētu secināt, ka latviešu auditorija ir tāda kūtrāka? Un tad tie ārzemnieki, viņi ir tie aktīvie. Ja? Es jūs izaicinu šobrīd. Tur vajadzētu kaut kā nobalansēt, jo man kaut kāds 3., 4. jautājums jau angļu valodā ienāca. Man te vēl jātulko, ziniet. Ja? Tas nav tik viegli. Tad tas jautājums ir apmēram par to pašu, vai ne, ka tās kompetences un cilvēku pieredze, administratoru pieredze atšķiras tomēr starp, kaut viņi visi ir profesionāļi. Vai šāda automatizēta administratoru iecelšana vai ieteikšana, es negribu sajaukt tos terminus, vai tur tas tomēr varētu kaut kā to visu tā automatizēt, lai tas viss būtu tiešām atbilstoši šī cilvēka spējām. Jo mēs te aizkadrā runājām arī ar ekspertiem. Viņi saka, nē, tur ir cilvēks atbilst, viņš atbilst. Viņi visi mūsu acīs ir vienādi. Kā tur īsti ir?
Protams, ka tas ir tāds koks ar 2 galiem. Protams, viņi ienāk profesijā, visi kā profesionāli, viņiem jābūt ir augstu kvalificētiem. Vienlaikus mēs paši labi saprotam, ja administratoram, kas tikko ir iecelts amatā, viņam ienāk maksātnespējas process, kur ir, piemēram, 1000 darbinieki bijuši, tā ir liels uzņēmums. Skaidrs, ka tas prasa ļoti lielu izaicinājumu. Tad ir šī izšķiršanās, es varētu teikt, pat tāda politiskā izšķiršanās, kā tad mēs darām, vai mēs tomēr viņus kaut kā gradējam, vai mēs tomēr viņiem visiem dodam vienādu iespēju izpausties. Jo arī varbūt tas cilvēks, kas tikko ienācis profesijā, varbūt viņš jau vairākus gadus strādājis nozarē, un viņš tiešām ir kompetents šādu maksātnespējas procesu novadīt atbilstoši likuma prasībām.
Jā, mēs tā pus pa jokam tur arī spriedām, ka ir jau cilvēki, kas nokārto autovadīšanas tiesības. Viņi drīkst braukt, bet mums ir tāda vēlme, varbūt, lai viņš vēl patrenējas. Un tad ir tādi, kuriem teica, mamma deva tur bernībā izbraukt pa lauka ceļiem, un viņi jau rulē, tā stabili.
Jā, tā ir ļoti līdzīgi.
Tā ir kaut kā līdzīga. Un tu tā korekti pasaki, nē, tev tomēr vēl šo lietu nedosim, to es vēl par zaļu. Man grūti tāds kritērijs izdomāt, vai ne? Labi, lai izdodas, un liels paldies par prezentāciju.
Paldies.
Paldies, Karīnai. Tā tad atgādina iespēju uzdot jautājumus. Turpat blakus pa labi, ja jūs skatāties šobrīd ekrānā, pa labi no tiešraides lodziņa ir jautājums sadaļa. Var droši rakstīt, var arī komentēt. Saņēmienu komplimentu, paldies. Tas vienmēr patīkami. Jā, tātad maksātnespējas process, ja mēs par to domājam, tad, protams, ka kaut kādā brīdī tur tiek veikta šī mantas pārdošana, ja tāda ir. Un tad arī mums nāk tālāk digitālajie rīki, un konkrēti runa par e-izsoļu sistēmu. Par izsolēm man nāk prātā kāds mazs stāsts. Es biju Latvijas valsts mežos, un Latvijas valsts mežiem ir daudz koku, bet gribētāju uz šiem kokiem ir vēl vairāk. Apmēram divreiz lielāks pieprasījums nekā ir piedāvājums. Un tad kā tu tā godīgi vari sadarīt to lietu? Un tad arī e-izsoles. Viņi teica ļoti labi kopš ieviesa, jo kādreiz atnāk uz izsoli uzņēmēji, konkurenti, un tur kaut ko iebaks dalkonī vai kā, un tās lietas tur kaut kā tiek novadīts. Kopš izsoļu ieviešanas, viņi saka, viņam ievērojami auga šī pārdošanas cena, tā kā tur ir jēga to darīt. Nez vai arī šādam aspektam Aivars, mūsu nākamais runātājs, pieskarsies, bet katrā ziņā no tiesa administrācijas. Viņš ir informācijas sistēma un tehnoloģija departamenta inovācijas sistēma attīstības nodaļas vadītāja vietnieks. Vienā elpā nevar pateikt viņa titulu, bet Aivars Švābi ir mūsu nākamais runātājs un runās par šiem te e-izsoļu rīkiem. Lūdzu, Aivar. Jā, drīkst aplaudēt. Drīkst. Arī jūs pie ekrāniem.
Tā, labdien visiem! Kā jau iepriekš tika minēts, mans vārds ir Aivars Švābe, un es jums pastāstīšu par elektronisko izsoļu vietni, par to, ko šī vietne piedāvā, kādi ir ieguvumi, kādēļ šāda vietne tika izveidota, un attiecīgi arī nedaudz par statistiku pieskaršos, kādi ir tie redzamākie ieguvumi, teiksim tā, ko izsoļu vietne sniedz. Lūk, te es esmu ievietojis mazu slaidiņu ar to, kā izskatās izsoļu vietni. Priekšskatījums, kā teikt, šeit mēs varam redzēt sarakstu no izsoļu vietnes mājaslapas, un arī šī te pašas izsoļu vietnes adrese. Tālāk jau iesim pie būtiskā, kāpēc šī vietne ir, kā teikt, svarīga, kādi ir viņas mērķi un uzdevumi. Lūk, tātad pirmais, kā jau iepriekš Oskars minēja, ir samazināt negodprātīgu vai preciesisku rīcību, jo, kā jau zināms, ir šie te sarunāšanas vai citādi iespaidošanas gadījumi, kad personu, kā teikt, šis īpašums tiek pārdots jau iepriekš, tad šis te elektroniskais izsoļu process šos te gadījumus izskauž pilnībā. Padarīt ērtāku un ekonomiskāku, tas nozīmē to, ka šī te izsoļu vietnes, kā teikt, platforma nodrošina to, ka nav katram izsoļu rīkotājiem jāveido sava platforma vai sistēma, kā teikt, un ir vienots šis te risinājums, kas ir pirmokārt izpratnes jautājums, otrkārt ekonomija, tā ir izmaksu ziņā šādas sistēmas noteikti izmaksātu ļoti dārgi. Šeit ir vienots risinājums, visiem saprotams, un pa lielam visu to, kam tas ir nepieciešams, var izmantot. Un otrais, šis te organizēta, tā kā izsoles notiek elektroniski, izsoļu vietne ir pieejama no jebkuras vietas pasaulē, kur ir pieejams internets un ir vajadzīgs tikai dators. Līdz ar to šie ir tie lielākie uzdevumi un ieguvumi vienlaicīgi, ko iegūst izsoļu vietnes lietotājs. Tālāk es jums pastāstīšu par veidiem, ko piedāvā elektroniskā izsoļu vietne. Tādi kopumā ir 3. Tātad pirmais senākais nekustamā īpašuma izsoles, kuras ir pamat izsoles, teiksim tā. Viņas mums tiek nodrošinātas kopā ar saslēgumu ar Latvijas zemes grāmatu, kas piedāvā to, ka mēs atverot konkrētu izsoles publikāciju, varam uzreiz pārslēgties uz zemes grāmatu un jau apsīties detalizētāku informāciju par šo te nekustamo īpašumu. Nākamais un arī nedaudz jaunāks, tika ieviests vēlāk, ir kustamās mantas izsoles kā tādas. Tās mums iedalās ķermeniskas un bezķermeniskas nedaudz sīkāk par to, ko nozīmē ķermenisks un bezķermenisks. Tas ir ķermenisks. Tās mums būtu, pieņemsim, automašīnas, transporta līdzīgi, kā slaidā redzams, pieņemsim, kravas auto. Bezķermenisks var pārdot kapitāla daļas vai akcijas vai jebko tādu. Un drīzumā vai nākotnē mēs plānojam piedāvāt arī nomas tiesību izsoles, kuras šobrīd ir jau izstrādātas, bet normatīvais regulējums pagaidām vēl to neatļauj piedāvāt, bet būs trešais izsoļu veids, kā teikt. Tad tālāk par drošību. Tātad drošība ir visiem svarīga, vēl vairāk, ka tas notiek interneta vidē. Tādēļ drošība pirmais un svarīgākais, laikam jau pat jāsaka, ir šis te unikālais identifikators. Ko tas nozīmē? Tas nozīmē to, ka izsoles laikā solot izsoles dalībniekiem vai veicot solījumus, neviens nezin, kurš ir veicis šo solījumu, jo viņam tiek piešķirts unikāls identifikators, un tikai pēc izsoles beigām šīs te dalībnieku vārdi un uzvārdi parādās, kurš tad ir veicis konkrētos soļus un kurš tad ir šis te uzvarētājs. Pirms izsoles beigām neviens nezina, kurš ir solītājs un kas ir šie solītāji. Un otrais ir drošības, šis te pārbaude, kā teikt, kas nozīmē to, ka mums ir tāds drošības pārvaldnieks, kas 24 stundas pēc izsoles beigām pārbauda pilnu izsoles procesu, vai nav bijuši kādi pārāvumi, kādas neatļauta rīcība, vēl kaut kas, un ja šāda pārkāpums tiek konstatēts, par to tiek paziņots izsoles rīkotājiem, kurš tad pieņem tālāk jau lēmumu izsolī pārtraukt vai izsoli atzīt par nenotikušu. Tālāk. Tātad par izsoļu organizētājiem. Kas tad ir šobrīd izsoļu organizētāji, kas darbojās elektroniskā izsoļu vietnē? Tātad šī sistēma iepriekš neminēja, bet principā viņa sākotnēji tika radīta priekš zvērnātiem tiesu izpildītājiem Latvijā, un pēc tam tika paplašināts šis organizētāju loks. Un šobrīd jau mēs esam liels bariņš, teiksim tā, pie mums ir 150 Maksātnespējas procesa administratori, kā izsoļu rīkotāji, un arī citi. Un citi, tas nozīmē, tās ir pašvaldības, iestādes un arī juridiskas personas. Tā. Un tad statistika nedaudz par tiem ieguvumiem, kas varbūt skaitliski parādīs, ko tad izsoļu vietnē sniedz organizētājiem. Tātad uz šo brīdi kopumā ir nopublicēts vairāk kā 25,000 izsoles, kas, manuprāt, priekš Latvijas ir ļoti liels skaits. Tad nākamais ir apmeklējumu skaits, kas loģiski noved pie tā, ka ir arī daudz lielāka iespēja pārdot par augstāku cenu savu īpašumu vai objektu, kas tiek pārdots, jo vidējais apmeklējumu viens skaits mēnesī ir 800,000. Tālāk par nedaudz instantu statistiku, kas mums ir augstākā nosolītā cena, tad tā ir 18 miljoni, kas ir bijis par nekustamo īpašumu, ja nemaldos 5 gadi atpakaļ, bet ir arī, kā teikt, ļoti lieli un dārgi objekti arī tiek izsolīti un arī nopirkti, kā teikt. Un šis tad ir tas skaitlis, kas ir zīmīgs ar to, kad viņš parāda, kāds tad ir šis pieaugums cenas no sākuma cenas, jo, kā mēs zinām, šīs atsavināšanas izsoles visas viņas ir ar samazinātu cenu no pārdošanas cenas, tad līdz ar to no šīs sākuma cenas tas vidējais pieaugums ir 28%. Kas, manuprāt, ir diezgan labs rādītājs un nodrošina arī, kā teikt, augstāku šo cenu, kas iespējams nebūtu, ja nebūtu elektroniskā izsoļu vietne. Tālāk par izsolēm, kuras ir beigušās ar nosolījumu, jo, kā mēs visi zinām, ir arī šie īpašumi vai objekti, kas nav tik pievilcīgi, lai lietotāji vai izsoles dalībniekiem viņi būtu interesanti, kā teikt, viņus nosolīt. Līdz ar to aptuveni gan arī 70% izsolēs atrod savu pircēju, kas arī, manuprāt, ir pietiekoši liels skaitlis, ņemot vērā tās lietas, kas iespējams var tikt izsolīts, kas ir, kā teikt, piespiedu izsoles gadījumā. Un visbeidzot, nedaudz par to, kas tad ir šie izsoļu solītāji, tad visvairāk mums pēc statistikas 75% gadījumu uzvar fiziskas personas, un atlikušies šīs ir nerezidenti, protams, ir juridiskas personas, bet arī tādi mums ir. Un par nerezidentiem pieskaroties, tad arī nedaudz tas mūsu skats starptautiskā līmenī, ko mēs piedāvājam, tad tāds nākotnes vīzija ir Eiropas Savienībā ir tāds projekts Lēla, kas nozīmē to, ka būs iespējams atrast Lēla portālā izsoles pa visu Eiropu. Šobrīd šis projekts ir tikai tā kā izstrādes stadijā, bet Latvija ir viena no partneru valstīm. Līdz ar to arī Latvijā publicētās izsoles būs iespējams atrast Eiropas Savienības pilsoņiem un iespējams arī šīs lietas, kas tiek izsolītas, atradīs īpašniekus ārpus Latvijas robežām. Otrs ir autorizācija, kā tad nerezidentiem pieslēgties elektroniskā izsoļu vietnē. Ir divi veidi. Viens veids ir EIDAS, tas nozīmē starptautiskā pieslēgšanās attiecīgi tā kā caur e-parakstu. Eiropas Savienības nav, protams, visa Eiropas Savienība iekšā, tikai dalība valstis konkrētas šajā projekta EIDAS, bet ir iespēja ar to pieslēgties pa taisno, vai arī var doties pie jebkura tiesa izpildītāja vai maksātnespējas procesa administratora, un tad šī persona tiks pie sava lietotāja vārda un paroles un varēs pieslēgties elektroniskā izsoļu vietnē. Protams, šis, kā teikt, profila izveidošana, tas ir klātienes pasākums vai arī ir vajadzīgs elektroniski parakstīts iesniegums. Un visbeidzot, jau pāris gadus mēs piedāvājam elektronisko izsoļu vietni divās valodās, tā skaitā angļu valodu, ne tikai latviešu valodā. Tas nozīmē to, ka mums ir iestrādāts automātisks tulkošanas rīks izsoļu vietnē, kas pārtulko publikācijas, un arī mums ir nodefinēti jau pārtulkoti attiecīgi standarta lauki, kas ir nemainīgi. Lūk, tā. Tad paldies, un vai ir kādi jautājumi?
Jā, paldies, Evar. Tā, kas ir? Mēs runājām. Pagaidām jautājumi no platformas nav ienākuši, bet man te radās daži jautājumi. Tad cik ilgi jau šāda elektronisko izsoļu vietne pastāv?
Elektroniska izsoļu vietne pastāv no 2015. gada.
Tas ir kaut kāds 6-7 gadi.
Jā, tas ir kāds 6-7 gadi, un sākotnēji, kā jau es minēju, ar šīm nekustamā īpašuma izsolēm. Tas pārējais, tas ir audzis.
Bet es vienkārši domāju, tad līdz šim ir publicēti 25,000 izsoļu.
Jā.
Tas vidēji gadā kaut kādi 4,000, droši vien tagad vairāk, sākumā bija mazāk. Kā tā visā noorientēties? Tur kaut kā iesastāda izsoļu vietnes lietotājs var kaut kā atķeksēt savus intereses, un tad man nāk jaunuma vēstules? Vai negluži?
Jā, ir arī tāda iespēja. Mums ir papildus pakalpojumi ērtībai, kā teikt, ka mēs varam abonēt tieši to, kā tu minēji, to, kas man interesē, pieņemsim, man interesē transporta līdzekļi, mēs varam šo te visu atzīmēt, un man nāks paziņojumi par to, ka kāds noplūcēs transporta līdzekļus.
Savukārt, ja es meklēju divas starp dzīvokli Sarkandalgovā, tad es arī varu atķeksēt. Varbūt ne tik detalizēti, bet...
Detalizācijā var aiziet ļoti dziļi, kā teikt, bet ir jāapzinās to, ka šīs izsoles ir individuālas, un katrs rīkotājs šo izsoli noformē un ieliek pēc saviem ieskatiem. Līdz ar to, ja tu norādīsi ļoti precīzi Sarkandalgovā divi starp dzīvokli un vēl varbūt tapeškrāsas, tad visdrīzāk viņi neatradīs, jo viņš būs piemirsis pielikt tapeškrāsas, kaut gan būs īstā.
Jā. 2/3 izsoļi beigušās ar nosolījumu, tas varētu teikt diezgan labs rādītājs. Kas notiek ar to pārējo trešdaļu? Vai iet vēlreiz šo procesu, vai tad mēs sakam, nesanāca?
To īsa elektroniska izceļvietne, ko es varbūt nepieminēju, visu darbību regulē normatīvais regulējums. Līdz ar to, jā, notiek atkārtota izsole, un tur jau ir nianses katram no rīkotājiem, bet ja mēs runājam par maksātnespējas procesa administratoriem, tad jā, šī te otrā izsole vai otrā kārta, un tur ir interesanti arī tas patiesībā, ka viņi ir vienīgie, kas izsoles piedāvā ar lejupējošu soli. Kas nozīmē to, ka ja pirmajā kārtā neviens nenopērk šo te objektu, otrajā kārtā viņa tiek ielikta ar nedaudz samazinātu sākuma cenu, un šī cena krīt. Un tas ir interesanti. Un tu vari iespējams iegādāties vēl izdevīgāk no pircēja puses.
Bet es tagad nesaprotu. Nu labi, tad ir otrreizējā izsola, cena, kaut kāda nomināla cena, tad es saku, es gribu. Un tajā brīdī viņa nokrīt, ja kāds ir pateicis, ka viņa grib?
Nē, viņa krīt, un tajā brīdī, kad tu esi pateicis, ka tu gribi izdaršot solījumu, šī summa apstājās. Un tad mēs sākam atkal solīt uz augšu.
Saprat. Tad viņa krīt, līdz pirmais ir pateicis, es gribu.
Jā.
Labais. Tad principā būtu ideāli tirgu vienoties, nesakam, ka mēs gribam, lai nokrīt lejā, ja? Bet tā nesanāk, jo viņi tur nevar sakomunicēt. Viņi ir ar kaut kādiem kodiem apzīmēti. Tur zaķīts 66 un tā tālāk.
Nu, apmēram, jā.
Jā, sapratu. Nē, nu labs tāds sociālais tīkls savā ziņā, tikai baigi anonīms. Rekuperāsa jautājumu, paldies par jautājumu. Vai fiziska persona var ievietot savu nekustamā īpašumu uz izsoli?
Fiziskas personas elektronisko izsoli rīkot nevar paši kā organizētāji, bet pastāv funkcija normatīvā regulējumā noteikta, kad ir publiskās izsoles, attiecīgi, kuras organizē Zarunātu tiesu izpildītāji Latvijā. Tas nozīmē to, ka Zarunātu tiesu izpildītājs to izsoli novadīs no ievietošanas līdz pat noslēgumam un nodos jau šim te, kā teikt, pārdevējam, nodos jau viņa rokā savedīs uz darījumu, kad ir persona, kas vēlas iegādāties jūsu mantu.
Bet tas ir tikai, ja ir kaut kāda ķibele un tur bankrots un tā tālāk, vai tas ir vienkārši, es domāju, pārdot savu sarkanogavas dzīvokli un es varu sazināties ar Zvērnātu?
Tas ir vienkārši, jā, ja tu vēlēsi pārdot, tas nav ķibele, tas ir, jā, es vēlos pārdot, man liekas pievilcīgi šī te platforma, es vēlos šo auditoriju aizskart, tad ir šāda iespēja.
Jā, nu rekā. Man draugs bija, viņš, es domāju, pirkt dzīvokli, un viņam ļoti patika viens dzīvoklis, viņi sarunāja ar to pārdevēju. Tas nebija tajā izsoļu vietnē, vienkārši caur kaut kādu publisko sludinājumu atrada. Un te brīdī, kad jau bija, tā kā jāiet, tur tie papīri jātais, un tas pārdevējs saka, nē, man te viens piesolīja vairāk, es viņam atdošu. Un tad mans draugs bija diezgan apmērās. Viņš saka, būtu varējis pateikt, ka šī ir izsole. Un tad es domāju, ka rekā, varbūt, ka šim te dzīvokļu pārdevējiem vajadzētu taisīt tiešām izsoli un būtu dabūjis varbūt vēl vairāk. Jo, kā mēs redzējām pēc datiem, tas cenas pieaugums ir par gandrīz trešdaļu.
Jā, un arī tas, kad nav iespēja atteikties, kā teikt. Tavam draugam būtu iespēja vēlreiz piedāvāt vēl lielāku cenu.
Jā. Nu, forši. Varbūt kāds jautājums te ir radies. Te jau visi eksperti, viņi jau neprasīs neko. Viņi tā kā koleģiāli, ko es tur iegāzīšu, var tagad grūti jautājumu. Paldies liels. Paldies par vēstījumu. Man ļoti daudz jaunas informācijas tiem, kas šajā nozarē strādā, droši vien. Ne tik daudz, bet katrā ziņā forši. Mēs esam noslēguši šobrīd pirmo sadaļu konferencē, un tas, ko es gribu uzsvērt, ir lūdzu esiet atpakaļ. Mums būs tāda garāka reklāmas pauze, bez reklāmas vienkārši pauze. Un plāns ir atsākt precīzi 1:00 pēcpusdienā, un tad, ja mēs tagad skatījāmies uz Latvijas maksātnespējas digitalizācijas procesiem un saistītiem digitalizācijas procesiem, tad pēc pauzes 1:00 mēs klausīsimies un redzēsim citu valstu digitalizācijas stāstus, un tas varētu būt ļoti iedvesmojoši un noderīgi jums visiem, tāpēc tiekamies 1:00. Paldies! Esiet sveicināti atpakaļ Maksātnespējas kontroles dienesta organizētajā jubilejas konferencē 20 gadi kopš mūsu valstī pastāv šāds dienests. Šī konferences daļa notiks angļu valodā, tā kā mēs klausīsimies dažādu ārvalstu kolēģu pieredzes stāstus. Līdz ar to, ja jums komfortablāk ir klausīties ar latvisku tulkojumu, noteikti atrodiet virs tiešraides ekrāna lodziņā. Tur 3 pogas var atrast to atbilstošo podziņu, kas saka, ka sola, ka būs latviešu valodā. So I'm switching to English now, as we have a program with foreign guests, foreign speakers in our agenda. So in this part of the conference, obviously we will focus on the international experience, and we will have several speakers sharing their successful and not so successful experience regarding the insolvency process and its digitalization. We will also hear from a representative of European Bank for Reconstruction and Development about more general tendencies of digitalization in Europe. So I'm very glad to introduce our first speaker, who is ready to talk about not so successful experience. That is actually quite a rare case. Usually people are quite good at showing off and talking about their successes, but not so keen about lessons learned and probably less successful experiences. The presenter comes from Poland. He is the Deputy Director of the Economic Law Department of the Polish Ministry of Justice. Emil Szczepanik, I'm guessing, is that was okay? He's nodding, so it's good. Hello.
Hello. Good afternoon to everyone. Thank you very much for the invitation from Latvian Insolvency Service, Control Service. I have to admit that we were influenced by your legislation on insolvency of consumers, and so it's very good that I can also provide you with some information about the way we try to digitalize our proceedings. I'm also really interested in the information that we're given today by your experts, and especially the way you regulated the nomination of insolvency practitioners. That is done automatically, so it's really interesting, and probably we'll try maybe to apply some solution that you have in your country, at least for consumer bankruptcies. As for our process of digitalization, it's as you said, probably everyone agrees that it should be a success story, and generally I must say that that we also follow this path, that we also think, and probably there are plenty of interested parties in Poland who think that our digitalization process is going in the right direction. But still, there are plenty of obstacles during that time of introducing the system to this digitalization into our proceedings. Next slide, please. About history, we just plan to digitalize our insolvency proceedings. In fact, by introducing a restructuring law. The law was introduced in May 2015, enforcing the 1st of January 2016. There was in that law also mentioned, in fact it was inscribed in the law, that these proceedings should be digitalized, but entering of force of that article was moved up to the 1st February 2018. At the end of the legislative process, it was clear that we won't be able to apply the software, the system into our system. So the law was introduced without this component, this very important component, and the whole proceedings were running still on paper. And in fact, that was also one of the reasons these new solutions that were introduced were not so welcomed, because in fact they were created as being part of a digitalized system where the information is moving quickly. So the work went on creating the system, and the decision was made to make it more ambitious way. So we decided to not only to digitalize the insolvency proceedings, but also to create a separate national register of indebted entities. So not to cover only the court proceedings, but also to create one place in our system where participants on the market could verify whether any entity or a natural person or a legal person is having any troubles with indebtedness, whether it will be by being in an insolvency proceeding or restructuring proceeding, or some types of individual enforcement actions. So the new law was enacted in 2018. As you see, still we hadn't the digitalized restructuring law, even as it was planned to have it on 1st February 2019, and it was moved up to the 2020. Then we had some new ideas about the reforms within the insolvency law, especially the consumer insolvency law. Some elements of these reform were copied from your system. Then there was COVID, and the simplified restructuring proceeding was created. So there were changes into our law. So the system, as the developer who was chosen in a tender proceeding, was signaling that they have to adapt the system to also constant changes into our material law on insolvency and restructuring law. At last, the system was introduced in 1st of December 2021. Next slide, please. So the main, there are two elements in our system. The first one is this register, the separate register for company register, and the register for natural persons. So as I said, it deals with indebtedness. Mainly, it gives information about insolvency restructuring proceedings, starting of the proceeding, and important parts of that, enacting finishing or adopting the list of claims, or the decision about the distribution plans, the end of the proceeding, also about the voting on restructuring plan in case of the repayment plans for natural persons. So that covers both natural and legal persons. There are also information about disqualification under insolvency law, but it doesn't cover the disqualification on penalty law. That may also occur, but this is a separate register for it into our system. Then we also provide information about recognition of insolvency proceedings, not only those covered by EU regulation on insolvency, but also as we have the model law on cross-border insolvencies adopted, so also recognition of foreign proceedings outside EU are also made public in this register. But it, as I said before, it also covers individual enforcement actions of bailiffs, social security, or tax authorities if they are unsuccessful. So this information is given also in that system, and ongoing enforcement actions in case of enforcement of alimonies. The next slide, please. I think that might be interesting for you for how much time we give this information. So generally the data is permanently in the system, but this data is available for public generally for 10 years, for 3 years after after repayment plan or a discharge. But discharge might also be decided without any repayment plan in Polish proceedings. So it might be like just 3 years for a debtor to be checked by others whether he had any financial troubles in case he decided to use consumer insolvency proceedings. But 10 years if the repayment plan is revoked. So that's coming back to the general rule in that area. In case of disqualification, 3 years after the end of disqualification period, and 7 years in case of unsuccessful individual enforcement actions. If the debt is repaid, so the data is erased from the system in case of those information about the individual enforcement actions. Next slide, please. As to the other part of the system, so the system as it was designed at the beginning when we were preparing the restructuring law, so the system that is to support the courts and insolvency practitioners in dealing with these cases. The general purpose to create the system is to have the access to court files by internet. We know that in insolvency proceedings in Poland, it was like these were proceedings that involved in some cases many participants, but to have real and on-time information about the proceeding, you had to come to court and see the files, and some of your decisions whether to intervene in the proceeding depended on the time when, for example, list of claims was lodged by the insolvency practitioner in the files. But then the information was made public, but not by communicating it to each and every one of participants, but just to make it public by press or by the official journal for commercial and court information. So accessibility to that proceedings were very limited. So to have the access to the internet is a major, I think, element that is the most, from the perspective of participants, is the most important part of that system and its functionality. The other thing that is important is to have the automatic transfer of data from insolvency proceedings to register. The courts in Poland to give information about insolvency to register, for example, the court register or to court register or to the register for natural person, they have to just fill out the forms and send it to these institutions, and they just have to enter it into the system. So now these data will be processed automatically. And as for the courts, we decided that by introducing the system that the court files will be fully digitalized. So in fact, it's a pioneering path that was taken here in our court system, because still we have generally we have paper files. So so all participants of the proceedings must load digitalized documents into the system, with some exceptions. So these are just the natural persons who are not conducting the business or they are not represented by professional lawyers. Then they may just send a paper document to the court, but then the court clerk must introduce this document into the system to digitalize it and to present it to the court. Also, as the the system was being prepared and the legislation for that was being prepared, it was decided that the documents to be lodged are to be standardized to enable data processing. So it's not like one form that is to be presented to the court, but we had to prepare the proper different forms depending on what kind of motion is to be lodged at the court. And also the system is supposed to help judges in creating the decision that is to be taken. So also it was decided that there must be forms for all types of decisions that are to be taken by the court, whether it is insolvency or restructuring or disqualification procedures. During the preparation of the system, the forms were being prepared with standardized squares where separate data should be provided in, so that then you can quickly process a lot of quantities of data, and to have the proper statistics and the proper way to, in fact, inform the participants of the proceedings. Also, to not only to just inform about the, but also to create documents that are needed for the proper conduct of the proceedings. For example, list of claims. If you have to put at the beginning of the proceeding, when you just lodge a claim in the system, you put this data into a proper form, then insolvency practitioner will then not be forced to put it again into the list of claims, and then needs to be accepted by the judge. And then if it's accepted, then it goes to the, for example, distribution plan smoothly without any additional work on the side of insolvency practitioners or judge or clerks. So that's how this was designed. Next slide, please. Just is to mention that we also, when we are creating the system, we're also thinking about the EU regulation about the firstly the separate register for insolvency. It doesn't have to be separate, but then to also create the proper interconnectivity with the justice portal. It was decided that the system must be new, so then we were so willing to create something more ambitious than just use the registers that we had. But then I will next slide, please. I will tell you how what we have now. So you can see the internet address to that system, so you can check how it looks. It's only in Polish, so it's not easy to use by foreigners, but still it can be used by them. For the court, not all forms were prepared at the moment we entered the system entered into force. There were many problems with taking decisions by judges. So the fact that especially in insolvency, we got a panel of 3 judges taking the decision to open the insolvency proceeding of businesses. That was a huge problem for the courts to just make it possible. So the line of support was created during the introduction of the system, and these obstacles were being somehow managed by, in fact, for at least 3 months at the beginning. So just around the beginning of March, the system 2022 began working a bit better. But the most important thing was the accessibility to that system by the creditor, because at the beginning the module to accept the claims was not working properly. So, for example, we've got time limit to present claims when you got the publication of insolvency. Then you got 1 month to lodge your claim, and then you have to pay for your participation in the proceeding. And in fact, for these 2 months, it was not possible to do it properly in the system. So that was a huge problem. And then we had to accept, the courts had to accept, so as the practitioners had to accept, because we changed this, so it goes directly to the insolvency practitioner, but through the system. So so they had to accept those that were in fact lodged after the deadline. There are many complaints about the way the data is presented. So if you got structured data, then you read it, and you cannot read it as a document. So it's not possible to read it as a PDF file. As for voting, that also has the system has the module for voting, but it still doesn't work. But so there are ways to circumvent this by voting outside the system, and then the data is put into that system. We had a problem with also foreign creditors, because in fact, as they are they have the possibility to lodge the claim as they are under EU regulation on paper, but we created the system that forced them to use the system. So, but of course, EU law prevails, and in fact, insolvency practitioners have to accept these data and in fact put it into the system by themselves. But there were many questions when the system began to function, how to in fact bypass all those elements that were created in fact to make it easy for the participants. In fact, that was the idea behind, for example, the standardization and creating of forms. But then some forms were not well prepared, or even there's lack of some of them still, because they have to be adapted in the system. And usually, and what is the most known way of solving this problem is to use the path of other files. So you put into the system a file that is not in a standardized form, so then it cannot be processed properly by the system. And in fact, the data must be put into a decision that is taken later in the proceeding by hand, by insolvency practitioner, or by judge. As we spoke, why our plans, our ambitious plans, still did not materialize in a proper way. We think that the problem is about wanting to solve all problems at once, and not to building the system step by step. So, for example, to work it properly, we need to have at least around 800 forms, both for participants applying or lodging the claims, or motions in the system, and forms for judges and for clerks that are also taking some decision during the proceedings. And that was in fact connected with the willingness to have all data processed quickly, so to have them separated in elements that then can be used in different documents and different decisions that are taken later in the proceeding. That was, I think, a step too far and a bridge too far, I would say. We should rather concentrate at the beginning to copy what's going on in the court and the circulation of documents in the court, and then we would just need 40 forms, and then the system could just be prepared earlier, in fact, and then we could build up on our experience and adding some the most important forms in a way that then they could be used. So I think, and now we are in fact backpedaling a little bit by using this other file method just to make the proceeding going. And well, it's depending whom you ask, they will tell you that okay, you can check the what's going on in the case, so that's a much better situation than before. But then those who are directly involved with the judges, especially not so young judges, or the insolvency practitioners, they are much more skeptical. They are complaining. They are saying, for example, they also complain about not have the possibility to just put the data automatically, for example, from Excel files. So they sometimes it's obligatory to provide a lot of data, especially if you've got the case of a bigger company, or more data is to be presented. So you cannot just use the interconnectivity with the system that is used by insolvency practitioner. So still a lot to be done. We are working on it. The developer is working on it. Each month the system is a bit better, but having in mind that we started in 1st December 2021 and still having so much troubles working on it, I think there was some miscalculation at the moment of preparing the concept, how the system should be built. And it also makes it harder for us now, for example, to make any changes into material law. So if you want to, for example, introduce some change in restructuring proceeding, for example, you have to just communicate it to the department that deals with the system, IT system, and usually they will tell you that they need 2 years to prepare it properly. So you have to use some additional methods to convince them that still you can make it faster. So that's the important thing is to have to plan it and to see obstacles that may occur well, but then you have to just being thrown in at the deep end, you have to just try to solve these problems. I think there is no way out of digitalization. I think it's not to say that it shouldn't be done, but it should be done step by step rather than to make revolution, because in the end you still do it by step. Thank you very much.
Thank you, Emil. Thank you for the presentation. We hear some applause for you as well. I have several questions if you have still some few minutes to spend with us. You said that as a rule, the data is permanently stored in the system, but in Latvia we have encountered this problem that you can't store data in regards to the GDPR regulation if there is not a sufficient reason for that. So please tell us how do you either overcome this or how do you address this issue with the GDPR?
Well, that's. I think that we deal with it by the fact that what is made public is at some point erased from the not erased, but not made, that is not available for the public. But that was, I think, technical problem. That was how it was presented to us. But I have to admit that I was not at the moment of creation of that system, and I was not responsible for it. I was only responsible for legislation in material law. So nobody presented me this problem now. So it was decided that at some earlier stage I will just may ask those who were responsible at that time, at the moment the system was being created, and the data there. I think that, as I remember, but that was not my sphere of responsibility at the moment. It was some technical issue that you have to have the data there to save the integrity of the system. But that's why this data is there. So because there are some information about the company, information about the also about persons in that company, and then if you raise the data, then you will have the problem to have access to other data that is not sensitive. But I can just send you information how it was solved. Okay, so if you are interested, then I will present it. But that was not my direct. Nobody just flagged me with that problem.
Right. Okay. All right. So if we are more interested, we'll just contact you and see how we can copy the solution from you. You mentioned that all the participants in the system must log digitalized documents, obviously, but how about the general readiness in Poland for the society? Are they sufficiently digital, or there was some backlash or some resistance in terms of the submission of digital documents?
Well, as I said, there are some minor exceptions, not so minor probably, but anybody who's a natural person, not being represented by professional lawyer, and the person who is not conducting business may just send paper document, and the document is being digitalized by the court. So that's how it's solved. So
okay.
People are angry with the way, and those professionals are in the way you have to now put this digitalized documents in the system, but is complaining about the way it was prepared by our developer and not the idea.
Okay. If we talk about the restructuring directive regarding data collection, will this system help Poland to ensure the implementation of the Article 29 of this directive? What do you think about it?
Well, depending at the end what the Commission will prepare, I think that maybe we will have to make some additional tweaks in the system to have the data as the Commission wants. But as I remember, there is also the sample method. So this is the way we at the end we will I think try to solve this problem. But as I said, the idea when we were preparing the system was to have as much data as possible. So with these standardized forms, we should have so much data that then is just to apply the method how to get this data from the system. But there are some elements about as far as you remember for example, the size of the company, for example, and to how to probably that where we could have problems to apply to the directive.
Right. My last question here. You mentioned this enormous number, 800 different forms. And when building the system, have you been thinking about simplifying this so that you don't have so many of those?
Yeah.
Obviously, you have thought about it, right?
Well, that was a kind of dispute. Well, I was not, well, there's no problem to tell it now, but because there was some willingness from one part of the Ministry of Justice to make it as audacious as possible. So there were some people who were saying that it's not we will have trouble with that. There were those who were signaling this, and there were those who were not seeing the trouble. And I was once at the beginning in a team that met with the IT guys, and we asked questions: what is possible, what is not, and they told us that everything is possible. So some believed in that statement, and some did not. And those who believed, they had the upper hand in taking decision where what will be prepared in the system. So that's the explanation. My opinion is that is crazy. Yes. And I must say that the system works quite. I'd say that we saved this because of COVID a bit. Because in COVID we, for example, created a very simplified restructuring proceeding that is little contact with court. It's just the opening by publication, so even there's no activity from the court, but just the use of the system to open the restructuring proceeding. And then you've got 4 months, and you have to just go to the court to accept the arrangement. And it's now that the most popular procedure, and it doesn't need forms. In fact, just no forms. So it saved the day. So because it was then put permanently into our law. So that's how I think we managed to circumvent the most difficult problem to have this plenty of forms in 4 types of restructuring proceedings. Now 3 other types of restructuring proceedings that we have are not used at all, and that's why we have no problem with lack of all forms that were needed to run those other proceedings. That's the explanation.
I see. I promised you that was the last question, but it wasn't. I have one more. Just came in from our audience. So, is this new register fully compliant with the what is prescribed in EU's regulation on insolvency proceedings and also EU's directive on preventive restructuring?
As for the system, well, there might be problem with this collection of data, as was said previously. It was designed to be fully compliant with the regulation. Maybe EU will find some deficiencies in it, but I hope not. As for the proceeding, insolvency restructuring proceeding, there is some incompliance, I would say. I don't want to invite EU to just to check us on that, but there is some lack of full compliance in case of restructuring. We got restructuring proceeding. It was designed during COVID. It's not perfectly compliant with EU regulation, but it's working. There are plenty of firms that is using it, and we will make some changes, but just a little bit. And I'm afraid that it might a bit make it more troublesome for the market. Yes, so not fully, but as registered, I think it's fully compliant.
What I hear is your approach is it's better done than perfect, right? In this
That's
great. Emil, we managed the presentation and the questions. It's all done. Thank you so much for joining us today.
Thank you very much.
And if we'll have any further questions, we'll send in text.
Yes, please, I'll answer.
All right. Have a good day. Bye-bye. Yes. So, as you see in the program, we have many more, well, not that many, but few more presentations in our conference today. And the next speaker comes from Lithuania and comes in person. So Lithuania is not that far away as Poland is. So, yeah, he's, well, let me read this. Head of the Analysis Division at the Authority of Audit, Accounting, Property Valuation, and Insolvency Management. Tadas Palevičius is our next speaker from Lithuania. The floor is yours.
So, labdien, good day, colleagues and those who are interested in solvency. First of all, the warmest congratulations to Latvian Insolvency Control Service for 20 years anniversary. And today I'm going to tell you about our whole path since the beginning till the present, emphasizing the most important steps we have done. So when we talk about insolvency in Lithuania, we have to go back to early 90s. 1993 can be considered the very beginning when the first enterprise bankruptcy law came into force. And it was a good start when the concept and practice system of bankruptcy was created and the limits of responsibilities and rights were established. Later, there were a few versions of the same law in 1997 and 2001. But since these are more legal aspects, I will not dwell on them. However, I will also mention some most important legal acts, in my opinion, in the following slides. Talking about digitalization, it started in the middle 80s, approximately 1996, 1997, when the first rudiments of the information systems were created, but with limited human and financial resources. Therefore, in principle, it can be considered an amateur activity because of often the aim was not systematically and promptly create common system, but create ad hoc functionalities that were suddenly needed. The real beginning of digitalization can be considered 2007, and the first official information system for collecting and processing bankruptcy data, IRBIS, was created. In Lithuanian, this abbreviation means Company Restructuring and Bankruptcy Information System. This start was important not only from the IT side, but also as a start that allowed for more efficient supervision. Faster processing of statistical data enabled policymakers to make operational data-driven decisions. Okay, let's go back to the scheme. And 2013 was important in two aspects. First of all, from the legal aspect and the IT. From a legal point of view, because the law on insolvency of natural persons has finally appeared, and it was possible to hope that Lithuanian citizens would run personal bankruptcy cases in Latvia less often, but that was only a hope. Still, a part of Lithuanian citizens are bankrupt tourists. On the other hand, closer cross-border relations are developing, so it's good news. More seriously, in 2013, an e-auction tool was also created, and in the next slide I will visually show the print screen. How does it look? it looks like this, and e-auction was a big push forward as the bidding system became more transparent, and moreover, with the passage of time, this tool has become very popular and now among people, known among people. Many different assets can be bought there. I mean, like transport, real estate, shares, IT equipment, and so on. And the fact that it is functionally quite convenient and has all the most important search attributes that meet the requirements of a modern and advertisement portal has contributed to its success. You can find here bets, time remaining until the end of the auction. Other important parameters can be seen every second. And e-auction is also important is that none of the interest parties have questions about transparency and why this particular platform has chosen to organize the auction. As a fact, I will mention that it is really popular, and I guess yesterday I checked the numbers and I have found more than 800 valid advertisements. So if anyone wants to see how does it look in reality, here's the link. You can also choose the English version and to go through this website. Okay, let's move on. In 2015, the selection program for bankruptcy administrators appears. And in my personal opinion, the emergence of this tool, of course, with a legal basis, was one of the most important in the context of digitalization and transparency. The initiative to introduce some kind of system for the selection of bankruptcy administrators came from our president, and therefore the political support was very strong, and it was only necessary to come up with the system itself and implement it technically. As I already said, the system has become much more transparent because the selection has become fully automated and depends only on the system's algorithm and not on subjective factors. However, the big challenge was how to include individuals, I mean natural persons, and the companies or legal entities in the same selection process. And a system was invented that calculates points for the natural person depending on the size of the bankrupt company. For example, 1 point goes for a small company, 2 for a medium one, and 4 for a large one. And that score is reflected in the workload, and experience points are obtained after completing the process. In the case of legal entities, it was decided to include all the employee workloads in the amount and to be divided by the number of employees. So to ensure the transparency of the system, a selection protocol is created after each selection process. I'll show you it a bit later. Also, since the data is public, we actually have about 600 auditors. Is it auditors? I mean, bankruptcy administrators, because they always check the results, especially if they lose the contest. If they have the slightest question, they turn to us. As a rule, there are no problems with the operation of the program, except for the interpretation of legal act in specific situations and how it is implemented in program's algorithm. However, there is no doubt about transparency itself. Okay. As I already mentioned, the system. Oh, okay, I need to go back, sorry. As I already mentioned, the system is designed so that after winning the selection, the workload increases and the chances of winning the next selection decrease accordingly. However, once the process is complete, the workload is lifted off the legal entity and adds to the experience. Therefore, there is an interest in concluding the proceedings faster, because in this way, the chances of winning increase and the state and the creditors win because the cases are concluded more quickly. Okay, the next important digitalization step is modernization of the already mentioned IT system IRBIS, and it became to Avnis. And Avnis has become a comprehensive tool which also includes the areas of audit and property valuation, and expanded functionality for performing inspections. It is also planned to fully digitalize the selection process for planned inspections in the near future. And very important to emphasize that the system is focused on complete transparency. So our employees practically do not have the ability to enter the data. Exceptions only for inspections, fines, and license information. However, for example, all information regarding the reports provided by administrators on insolvency proceedings is obtained without the possibility of correction. Employees have only one option: to accept the report or return it to the sender for correction. It is also important that Avnis data is audited. I mean, all actions, who perform them and when, are stored. And if there's a slight suspicion of mistake or employee abuse, it can be checked. Okay. Okay. Yeah. Although my presentation is focused on digitalization, but I cannot forget the law on insolvency and legal persons, and why it is so important. It combined two licenses, bankruptcy and restructuring, into one, insolvency. It is also important to know that the procedures for transitioning from restructuring to bankruptcy and vice versa have been simplified. We hope that this will have a synergy effect in the long run, although we have to admit that restructuring is still very unpopular in Lithuania. Also, this law laid the legal basis for a creation of new IT tools as new duties of administrators were established. For example, to submit monthly reports on the progress of insolvency process. Okay, let's move on. In 2021, the insolvency administrator selection program was updated, and some principles of how the algorithm works have been changed. For example, how differently the workload is calculated, etc. However, again, all changes were made with serious legal justification. In this case, a government resolution. It is also important that public authorities, including our Ministry of Finance, hear the comments of the market participants and take them into account when developing the legislation and implement it. And here I tried to show very briefly the main steps of selection program. You can see it. Of course, it's only main steps, because otherwise it would be tough to understand. But what I'm trying to say that most of these steps are actually digitalized, and only the steps which is impossible to make digital is still not digitalized. For example, the court's decision to open the case or not, or to push the button when they start the selection process. You know, you cannot put into the algorithm such things, but all the calculation, all the other things are fully digitalized. And as I promised, you can see the sample of our protocol. It's only the first page, and it shows. You can see here many information. For example, the date, the company, which bankrupt, the name, the code, address, also some financial data, the property, the worth of the wealth, creditors' requirements, creditors' numbers, and on the bottom you can see the administrators who are participating in the contest. The group means that, for example, C, it's a large administrator, and there are many other information, for example, workload, as I said. And all these numbers, which are blue ones, you can check. It's like active links, so you can check if it's calculated correctly if you want. Yeah, and in summary, the reason why this product was so successful. So first of all, that there is a lot of political support till now. Also, the realization that IT solutions need a strong legal basis. And the interaction between these two components is extremely important. Also, avoiding any possible speculation about transparency, the system works in such a way that there is no human factor involved, except for the steps, as I said, that are impossible to put in the algorithm. I hope you are still awake, because not so much left. Yeah. Okay. And now we are on to 2022-2023, and this year we have created a restructuring wizard, and next year we will finish. Actually, at the end of this year, and next year we will start insolvency portal. So now about each other very briefly. Restructuring wizard is intended for small and medium-sized companies to objectively assess their financial situation. The wizard may suggest restructuring as an option. In order to prepare a restructuring plan, the restructuring wizard will help you to do this. And it also contains summarized information on insolvency, like legal acts, etc. So here you can see the main parts of this wizard. As I said, the first part is for entering data and getting the answer if you have, let's say, some financial problems, and you can get the suggestion to think about restructuring as an option. The second part is for preparing the plan if you want to do that, and the third part is for aggregated information. And here's an example. How does it look? As I mentioned, in order to self-assess your condition, you need to go through 10 steps to answer all these questions and fill the form. And what is important, that you don't need to register to use this wizard. Not summarized data is stored, so complete anonymity is ensured. Therefore, we hope that this will increase confidence in the tool and will lead to more use of it. And all this will lead to the popularity of restructuring, because in Lithuania it's still very unpopular. And now briefly about Insolvency Portal. It is important that Insolvency Portal is related to the previously mentioned law on insolvency of legal persons, and the portal itself is focused on protecting the interests of the clients' creditors. We are currently running this project, and as I said, we hope to finish it till the end of this year. Insolvency Portal itself consists of 3 large blocks. It's a general information available for anyone who wants it, information or functionality for supervisory authority employees, insolvency administrators, employees of the courts, and the third most important is information for the participants of the case, which is not accessible for anyone else. Now the participants in the case can get the most of information using our, for example, court IT system, but we hope that our added value will be that it will be possible to find not only core decisions of the documents, but also visualizations, graphs, summarized information, open data, and so on. As an example, I can give you, if I'm the participant of the case, and my administrator carries out the process for 1 year, and the law provides for a period of 2 years. How should I know if he works efficiently? Yeah, and using this portal, when I see the aggregated information, some statistics, I can compare and for example ask him what's the reason why he's running the process longer comparing to the average of Lithuania. And there is, I think, the last slide. Just very briefly, you can see the diagram, how many integrations we plan with other information systems. So therefore, we hope that after the completion of this project, this tool will be really useful with relevant information and recognized by the users. So thank you for your attention.
Thank you, Tadas. Before we let you go back to the seat here in our conference room, a few questions that have come in from our audience. What about the selecting the administrators for the procedures? You said that you follow the size of the enterprise, and is it sufficient enough as a criteria? Because there could be cases with this, I don't know, smaller company with very sophisticated legal procedures and everything that is related to that.
I would answer that the only one exception is when we talk about banks and other financial institutions. There are some limits, like you cannot get the legal entity from the financial sector if you have no experience. So when the judge runs the selection, he can put a mark that you need to have such an experience.
Right.
But it's the only one exception, I think.
Okay. We asked the same question to our Polish colleague Emil about the system's compliance with the EU's regulation on insolvency proceedings and directives on preventive restructuring. So what about Lithuanian system? Is it compliant?
I would say mostly it is compliant, but there might be some let's say challenges, because some of the data is stored in other institutions' IT systems, especially in the courts IT system. So we need to cooperate and to change, to make integrations between IT systems. And well, I'm not sure if no changes must be made in the future in our system, but hopefully not.
Right. There's one more question about selection process. What's your feeling? Is it viewed in general by involved parties as an efficient process? Isn't it too time-consuming, perhaps?
Well, as my previous colleague said, it was a political decision how to run the selection program and what the principles should be laid down. But I think that it doesn't take so much time or consuming much time, because most of the steps are digitalized fully. So I think that in the light of the idea, which was or the principles which were agreed to implement, it's one of the best ways to implement it.
So it's okay. All right. Yeah. Okay, thanks for coming, and I hope you stay for some time in Riga and enjoy its beauties that we can offer.
Okay, thank you.
Thank you. All right, it's time to broaden our perspectives a little bit. So we will not focus on a single country during our next presentation. That would be run by the representative of European Bank for Reconstruction and Development. And the topic goes like this. It's very interesting. Going digital on insolvency, selected experiences from emerging economies where this bank invests. So our next speaker, Catherine Bridge-Zoller. Hello.
Hello, and thank you very much for the introduction. Good afternoon, ladies and gentlemen. I hope that you can hear me.
Yes, it's all good.
Okay, excellent. So I would just like to start by saying that I'm delighted to be able to participate in today's event on behalf of the European Bank for Reconstruction and Development, where I am a senior counsel specializing in insolvency and restructuring, and I've been working for the last 10 years. So I am speaking to you actually today for the last time from our EBRD offices by Liverpool Street, as tomorrow we are moving across the waters to Canary Wharf. Before I begin this talk, I would just like to thank the Minister of Justice, the Ministry of Justice, and Ms. Stein at the Insolvency Control Service for organizing, I think what we would all agree is an incredibly exciting event on this highly topical issue of digitalization and interaction of that with insolvency. And congratulations, of course, on the 20th anniversary of the Insolvency Control Service. Today, so next slide, please. Today, I will speak first about the EBRD's new digitalization transition mandate and how it links with insolvency standards and changes in the EU. Then I will briefly present the main findings of our 2022 assessment and study on insolvency frameworks, which focused on these business reorganization or restructuring procedures, which the Lithuanian representative indicated are not always that popular in a lot of the economies where EBRD is active. And then finally, I will discuss new EBRD policymaking initiatives in the area of insolvency and try to map out where we see the future development and reform perspectives in the insolvency space. Next slide, please. So the advantage of being at the EBRD is being able to witness, of course, at a high level, what is going on in terms of policy making and trends in insolvency across a wide range of jurisdictions, because we cover, of course, a number of EU countries, but also non-EU. And here you can see a map of the 37 countries where the EBRD invests, including in Central Europe and the Baltic states. And of course, you can see here that Russia and Belarus, which were countries of operation, are no longer receiving any funding for projects or technical cooperation. In fact, we've closed our offices there. And in Latvia, I have personally been working with the Ministry of Justice on 2 EU-funded projects in insolvency since 2019. And we've had an excellent cooperation. Next slide, please. So before continuing with the presentation, I wanted to share a few terms that I have found useful when thinking about digitalization, because at the beginning, when we started talking about it from a policy-making perspective, there was some confusion between were we digitalizing, were we digitizing, and now we have this new concept of digital transformation. So I think the most useful definition for me of digitalization is here at the top of this slide, and it's really the use of digital technologies to change a business model and provide new revenue and value producing opportunities as in the process of moving to a digital business. So that's very much what the EBRD is thinking about, because we're a bank investing in primarily in businesses across our economies of operation. But of course, you can't digitalize if you have everything still in paper format. And I still remember visiting not that long ago some countries where, you know, going to the courts, you would see just enormous piles of documents, apparently perfectly filed, but still, you know, the extent to which paper still continues to be dominant. Really, digitalization is now a very important part of the EBRD's strategy. So every 5 years we set out our strategic and capital framework, and this time we identified digitalization as one of the 3 cross-cutting themes that we need to work on as an institution with national authorities in order to bring about positive change. So we are very much looking to support national authorities and businesses that want to digitalize. And we are also supporting, of course, another 2 areas which I think are very important alongside digitalization, and these are promoting green, low-carbon economies, and also promoting equality of opportunity of access to skills and employment, especially amongst young people and women and underserved members of the community. Next slide, please. So this sets out just some more details about the EBRD's objectives and our thinking around digitalization, which we tried to consolidate in this paper. And I think here I should just mention briefly why the EBRD was established. We were established in 1991 against the background of the collapse of the former USSR, and we were set up as a multilateral development bank designed to foster transition towards open market economies and to promote private and entrepreneurial objectives. Now, over the years, this transition mandate has evolved, and we now focus on a series of qualities which include helping our economies to become more competitive, well-governed, green, inclusive, resilient, and integrated. And digital transition really cuts across all of these. So we have 3 areas of focus now for our strategy on digitalization. The first is foundation, so trying to lay the foundations of a sustainable and inclusive digital economy by promoting the right kinds of policies and regulations. The second is adapting, helping existing organizations to adapt to digitalize their services. And finally, innovation, so really supporting those digital first clients and businesses to help them to grow. Next slide, please. So I just wanted to mention a few examples of some of the digital initiatives we've been involved in recently before narrowing the scope to talk about insolvency. So in Armenia, we've been involved in a foundational project which looks at trying to modernize the power supply network of Armenia. The example in Uzbekistan you see here is about adaptation. So we've helped a bank, so TBC Bank, offer more innovative digital products to its retail and micro and small business clients. And finally, in Turkey, we've been investing in equity in an e-scooter and e-moped initiative. And alongside these 3 sort of streams of activity in digital programs, we have been very active on the policy-making side. And I think the most relevant areas are really around court systems. So at the moment, we are looking at the feasibility. I think we've done the feasibility assessment. We're moving ahead in Ukraine. So Ukraine is very much still in our, the center of our operations, and we are looking at helping Ukraine set up a fully online court for small claims, just to accelerate access to justice, improve access to justice. And we've also been very innovative on the procurement side, so helping to set up digital procurement platforms in line with international practices, and also turning those platforms around. For example, here I think on the slide you see the example of Ukraine, turning those around so that platforms are also can be used to sell. So we developed in Ukraine Prozoro Sale, which not only sold the assets of all these insolvent banks in Ukraine that happened after the 2014 crisis, but also non-performing loans and foreclosed assets. So in a sense related to insolvency. Next slide, please. So now narrowing the focus and thinking about what can digitalization bring to insolvency. I think we've heard a lot of different ideas and thoughts today. And I mean, we tried to sort of distill these into 4 key areas. I think here, the first is really around efficiency and timely resolution. So what I have heard over the course of my career at EBRD and going from jurisdiction to jurisdiction is really a complaint that often insolvency processes are very slow and time consuming. And I think what's very important about digitalization is that you can track all of this much more easily when you have, for example, a digital court case management system. You can see very clearly the progression of the case. You can also be much more efficient in communicating with creditors and so forth. And I think there's also a significant potential for cost benefits, cost savings, because of course with digitalization, as we've also heard, I think we heard the Minister of Justice mention that this morning, it also enables us to reduce perhaps some of the manual human labor involved, also in from the perspective of a bankruptcy administrator, or from the perspective of a court or supervisor, such as the Insolvency Control Service. And I think we also heard this morning about the new auction system, and how really digitalization can also help reduce costs in insolvency by perhaps increasing, or it helps to increase the potential returns to creditors in an insolvency process if that auction system is able to create a more vibrant marketplace for potential purchasers and investors. So finally, the second 2 blocks are really around greater transparency. This has been an issue for many jurisdictions where perhaps creditors don't receive full reports on the progress of the insolvency case, don't have access to information, receive reports late. And I think digitalization is very important for improving that transparency and accountability as well. And if as long as systems are aligned, and there is always an alignment within a country as well as outside, I think it can also really be important on a cross-border level, and that really has been that agenda is being pushed by the EU. Next slide, please. So at the time of the pandemic, it was a chance for us to also reflect on what we consider our core principles for insolvency. So the EBRD, like a number of international organizations, such as the World Bank, we we engage in standard setting. We find it useful to set out some principles that we follow for our projects. It helps us just to distill that thinking. And when the COVID pandemic hit, it was very much clear that we all had to, we had to transfer to remote working. I worked from home for a very long time, and everything had to be done remotely. So we created a new principle. This is all developed in house, and it was really about trying to reflect our understanding from projects. But we created this new principle, 14, which is really about it's about digitalization, and we believe that a modern forward-thinking insolvency system should adopt digital tools to increase the transparency, efficiency, and also cost-effectiveness of insolvency procedures. So for the reasons I described earlier. Next slide. And this reference to digitalization, you can find it in other international standards, often in passing. I mean, UNCITRAL has been extremely active, I think, on coming up with model laws on electronic signatures and electronic commerce. It has looked and considered the role of digitalization and, above all, the use of electronic means as part of its recent expansion of the guide on insolvency to micro and small enterprises. And the World Bank also references this, so where appropriate, using electronic means and tools, particularly for simplified proceedings. And I think UNCITRAL has been involved on a really important initiative, and I think this is another area just to think about, is sharing international jurisprudence. So UNCITRAL has a database of insolvency judgments that are relevant, for example, for its model law on cross-border proceedings. And I think digitalization, of course, national insolvency systems still look very different. But there are some areas of common interest where such as cross-border insolvency, where it's really important to be able to share information as well, and to use these sort of digital platforms. Next slide, please. So I'm sure many of you are familiar with the EU's digital agenda, but I think I just want to reference that in this presentation because I'm very grateful that the EU has now started to get involved, particularly recently in relation to the Preventive Restructuring Directive, because it's made it a lot easier for me as a policymaker, not only in the EU but also outside the EU, where EU legislation is very influential. And it's clear from the regulation on insolvency proceedings, the recast regulation from 2015, and also the 2019 directive on preventive restructuring, that the EU is trying to increase the pace of digitalization of insolvency registers and databases. And this is because, without data and without information, it's just simply not possible for the EU to benchmark national insolvency systems and to understand what needs to change from a policy perspective. And it's this divergence amongst insolvency systems that's seen as being one of the significant barriers alongside, for example, tax, to the EU's push for a capital markets union. And outside of the EU, I see particularly, in countries such as Georgia, Moldova, Ukraine, where EBRD invests, the influence of the EU and this desire to align with the acquis. So I think there is definitely going to be some movement here, I think, to follow the regulation, the directive. And it certainly with the regulation, it's very it's a very positive development that certain data will be centralized and made publicly available, and there will be this interconnection of insolvency registers, which is still, I think, in process. And with the directive, I think you see in a way the ambitions of the EU to at a future point, for example, to collect information on recoveries and insolvency, but you see that they haven't made certain data fields mandatory yet, because there's still quite a way to go. Next slide, please. So I think here this is just this just sets out a little bit of information on some of the new or existing court digital plans by the EU. And what we know at EBRD from the assessment work, the research we do across all of these jurisdictions, across the 37 countries where we're investing at the moment, is that insolvency is really a court-driven process. So any digitalization changes that affect the courts have a very important positive effects for insolvency processes. Of course, the only issue is that there is at the same time a push to or a policy initiative to try and encourage for more decision making and agreement between a debtor and its majority creditors outside of a formal process before it even reaches the court. So the so-called pre-packaged reorganization plans, which I think in Latvia are these extrajudicial legal protection proceedings. So the idea that you can do some of the work outside the court because it's more efficient and also potentially less public and value destructive. So I think but anyway, I think these court digitalization initiatives in the EU, such as the, starting with this recast regulation on court cooperation, which came into effect in March, and the plans that the Commission has for speeding up digitalization of justice will have tremendous implications also for insolvency. The next slide, please. So here I just wanted to say a few words without, maybe I probably won't be able to go into a huge amount of detail, but the EBRD recently published, I published an assessment, a really detailed piece of research across all of the jurisdictions where the EBRD invests and has invested. And it didn't focus on digitalization, but I think some of the findings from the assessment give us an indication of how digitalized our countries, the countries are where we invest, and what kind of digitalization gap exists. I think what we've heard today from Latvia and also from the results of our assessment really show that Latvia is very advanced in terms of digitalization of insolvency compared with other jurisdictions where EBRD invests. Okay, so the assessment was run across the whole EBRD regions. And we developed a methodology for scoring, which included some objective as well as subjective factors. We looked at legislation on the books. We analyzed this thoroughly. So all the different national legislation in translation and in original where we had native speakers. We consulted with at least 2 law firms per jurisdiction, so everything was verified. And actually, where we could, we also consulted with national authorities. So we're very grateful that the Ministry of Justice of Latvia was able to look at our overview of the Latvian insolvency framework. And we looked at scoring across the structure of reorganization procedures. So these are the procedures. We were focused very much on procedures aimed at rescuing businesses. We didn't look directly at liquidation. And we analyzed also how flexible, how efficient, and how effective they were. Next slide, please. So here you can see the overall scoring of the assessment. I hope you can see it. It's a bit small on my screen, but you can see that Latvia scored very, very highly. I mean, Latvia came in seventh place. And the little yellow bar that you can see at the top was a bonus score that we awarded to countries that publish clear and comprehensive insolvency data online. I mean, there were some marks for countries that provided anyway, you know, and provided in paper form, but we were very much focused on the online publication of insolvency data. Next slide, please. So I think here it's, as I say, we didn't focus directly on digitalization, but there is a correlation between how much data was disclosed and also how digital the insolvency framework is. And out of all of the EBRD countries of operation, the existing countries where we invest, the 37 countries, only 4 of those countries that were included in the assessment, so Greece, Latvia, Slovak Republic, and Slovenia, had an electronic dedicated insolvency register in electronic form. Czech Republic has since become a country of operation and does have a dedicated electronic insolvency register, but was not part of the assessment this time. But it's quite striking that 10 out of all of the EBRD countries where we invest publish absolutely no insolvency data, and there's no evidence in these countries that there is much in the way of centralization of that information and data. And courts are a very important data point. We've also heard about bankruptcy administrators, of course, and their reporting, and that they're also very important for data purposes. But there were very, very significant divergences also within courts regarding data. So in some cases it was centralized. So for example, in Ukraine, it was the Supreme Court. But in other countries like Moldova, each court was responsible for gathering its own information on insolvency, and there wasn't a centralized authority. And I think it is difficult to compare insolvency systems given the differences in structure, but it may be possible with this data in the future, especially if there is greater convergence. And I think that will, or is likely to gradually take place at EU level. And as part of this, we really do need to think about where the data comes from and the need to invest further in court systems and in bankruptcy administrators, as well as in sort of digital IT. Next slide, please. So here is just an overview of, with a breakdown of the data transparency score for Latvia. So Latvia scored 10 out of 10 because it publishes, it centralizes and maintains its insolvency data. It publishes comprehensive data on everything. It regularly updates the data in real time, and it has the possibility of both aggregating and disaggregating data. And this is for some countries, this is quite advanced because, as I've mentioned, centralization is an issue for many countries, and also what is an issue is this aggregation or disaggregation, because these prepackaged reorganization plans that I mentioned earlier, you know, these plans that are conducted mostly out of court and then submitted to the court for approval, these are present in about half of the countries where EBRD operates. But sometimes information or data around these plans is not captured. For example, in Serbia, it's not currently captured, but they they want to do so going forward. Next slide, please. So we have a new digital hub at EBRD now, which helps to us to have a better oversight of all the digital projects we're doing, and we have a new investment pool for non-EU countries primarily, which is all about investing in technical cooperation projects that promote new technologies. And here I just wanted to give you a few examples of some of the projects I'm working on, just so you see the types of policy initiatives. So we have an ongoing project with the Ministry of Justice in Latvia, which is looking at designing information sources on insolvency, because we know that for people and businesses to take earlier action, they also need that information. They need to understand what is still considered in many ways a very technical area of law and practice, and it's obviously not it's not part of the day-to-day operations of businesses or the day-to-day lives of consumers, thankfully. So here you can see, one type of initiative is this design of information sources that really capitalize on digitalization as a means of communication, so websites. And it also gave me an idea for a project, so the Latvian project gave me an idea for a project which I've developed in Georgia, Moldova, and Ukraine. And this project has been around delivering legal and business advice in sort of generic form to businesses to help them, especially to small and medium-sized businesses, to help them adapt in the COVID and the post-COVID environment. And it includes advice on how to digitalize. The second type of initiative which we're seeing, and I think we'll see more of, is around the creation of new IT and digital governance models for regulation of insolvency. Now, when we did the assessment, Latvia was among 9 countries which have a dedicated insolvency regulator. So regulation is still an area that needs more development, but as it does develop, and I think there are real merits in regulating and having oversight of insolvency, I think we'll see more demand for IT and digital governance tools to enable this risk-based supervision, remote supervision that we heard this morning, and also in Serbia, where we're working at the moment with the Bankruptcy Supervision Agency. There is a new, the agency has got a new role of producing statistics on bankruptcy, and it's looking at using its IT systems to track various data and to understand better the impact of the insolvency processes on different types of company, for example, and different members of society, for example, women. We're also looking very much at electronic platforms. This is really in relation to the sale of non-performing loans, so it's connected with insolvency, but not directly insolvency related. And I led a project in Armenia, which was around helping the insolvency court, which was a newly created court, think about how to digitalize its operations. Next slide, please. So here, I just wanted to mention that we're doing some research at the moment within the EBRD, looking at what the level of digitalization of court systems looks like across EBRD economies. And this is really part of this initiative that I mentioned earlier about the Ukrainian online court for small claims. So we're trying to also get a better sense of if this takes off in Ukraine, where in the future, where where we should also consider doing a similar project. And we're trying to understand how advanced the different court systems are. there are, here you can see on the slide that there are a few countries that we've identified which have electronic court case management systems, such as neighboring Estonia. Next slide, please. So undoubtedly, as we've heard today, the pandemic has spurred on this growing awareness of the need to digitalize and to transform our ways of working. And it was the perfect occasion to test it all out. I mean, we didn't have much warning. It was considered a bit of a force majeure. So it was the perfect occasion to switch to these online hearings and filings. And in fact, it was possible in a majority of EBRD economies for hearings to take place remotely. And we know this because we looked into this as part of a recent survey with our team of economists that we've been supporting. And we know from this that what was quite interesting for me was only 18 of the countries where EBRD invests out of the 37 introduced emergency bankruptcy legislation, or insolvency legislation. It was much more popular to introduce banking regulations and tax amendments. So 18 of the countries did introduce emergency insolvency legislation, including Latvia, and Latvia and Ukraine were the only two that introduced measures to allow e-voting by creditors, which I think have been retained in Latvia. And we still need to do more research into this to understand the need. Next slide, please. So this is the final slide, really, and it's just tried to set out some thoughts here on what the future looks like for policymakers such as myself, and where we as an institution might want to focus our efforts. So I think we are seeing definitely a move towards greater digitalization of insolvency. There's tremendous potential. There's still a long way to go, I think, for a number of countries, such as and regions as well, where we've seen lower rates of digitalization, such as the southern and eastern Mediterranean region, and North Africa, where EBRD invests. But digitalization can bring a lot of benefits. So we can look at electronic insolvency and pre-insolvency processes. We've seen this also with early warning systems, so how to use digitalization also to trigger warnings that businesses need to take action. Electronic court case management, which is a much broader topic, but will have a significant impact on insolvency cases when it extends to insolvency cases. The use of digitalization to carry out e-sales or auctions in insolvency proceedings, which are typically, I mean, this is another debate, but typically auctions or sales are conducted, even of secured property, are conducted by through a court-managed or overseen process or involving a court official, such as a bailiff. So I think the digitalization process can bring tremendous benefits in terms of increasing the potential acquirers, helping to anonymize, as we heard earlier, the acquirers, because sometimes turning up and going to auctions have been issues with, in some countries, and hopefully achieve better returns if we're looking at a liquidation to creditors. Digital reporting, I think, will be extremely important. Of course, for digital reporting, we also need to think about meaningful reporting and trying to encourage not just pro forma reporting, but something that actually speaks to creditors and other interested stakeholders. Collection of data is also important, because we can, with digitalization, try to look at centralizing the various data fields and sources. We can also look then at the future at also analyzing and producing more informed statistics. So there are numerous benefits, primarily much more informed insolvency policies and decision making, because insolvency has sometimes been done a little bit in the dark, greater transparency, and also facilitation of cross-border proceedings, provided there is a certain harmonized approach. But two areas of constraints to mention, I think, that are particular to the insolvency field, and it's around this out-of-court proceedings or negotiations, and some aspects that may remain outside of the court sphere, either because the court isn't overseeing it or because another administrative authority is, and there needs to be a connection. And also the respect for fundamental rights, because I think that means that the paper-based options and maybe also the sort of duality of approach is likely to remain for some time. And that's it. Thank you very much for your time.
Thank you, Catherine. We have some questions that came in. I believe you actually touched upon those topics already, but let's just maybe summarize again. For example, how will EBRD promote greater digitalization of insolvency through your policy making? I think that was in the last slide you explained this, but maybe we can just do a recap.
Thank you very much. I think the last slide just shows that there's so many different areas that where we could focus, and so part of it is also about deciding, what next. I think next for us is really building on the assessment that we conducted, and I'm at the moment, I've just started a new project which will look at preparing a guide to insolvency regulators, explaining so with an overview of where the trends are in terms of capturing insolvency data, why we should capture the data, how digitalization can support regulatory functions, and what they can do with the data. So that's my next initiative, is really around data, because I just see this big data gap, and I see that digitalization is essential really for closing that gap, and also dealing with the issue that we face in a lot of jurisdictions, that they don't have the human resources to properly regulate insolvency proceedings, and we need to think a lot more about how we can use digital tools to maximize what resources they have. Thank you.
Right. Another one, perhaps again, similar case of doing a recap. What's your bank's strategy for future insolvency projects? Is there a general strategy at all?
I would say it's still under development. So we are looking, I think, primarily at this data regulatory angle that I discussed, and also. As you may know, or some of you know, we have been very much focused also on insolvency practitioners, or bankruptcy administrators. So I think we will be focusing primarily, or I will be focusing primarily on projects with regulators. So looking at what systems they have for effective supervision, and also production of statistics and explanations related to the use of the insolvency framework, and at the same time also pursuing projects that focus on building capacity among insolvency practitioners, and looking in particular at the standardization of reporting and forms that are used by insolvency practitioners within an insolvency process. Because I think we've also heard from this morning's discussion that standardization as well is essential for a full digitalization of insolvency systems.
What is your view on how digitalization could facilitate cross-border insolvency proceedings between different countries?
Oh, Well, at the moment, we see big gaps of course, the EU has its own cross-border insolvency framework with the regulation, but we don't. In doing this assessment, one of the aspects that we looked at and we've been asked to look at in more depth by UNCITRAL is around cross-border insolvency, because the provisions around cross-border insolvency are really underdeveloped outside of the EU. We did some research looking at, for example, the Eurasian Union, if there's anything that's coming out of that, but so, to our knowledge, there's nothing. You have a number of countries that have incorporated the model law on cross-border insolvency into the UNCITRAL model law into their insolvency frameworks, but you don't see a lot of it's not that common, and it looks very different from country to country. So I think before we can even talk about what digitalization can do, we also need to think about that groundwork that needs to be done on the legal side, and also whether we can promote as EBRD greater adoption of the model law.
Right. To sum up our little conversation here, what's your general feeling? Is Europe ready for digitalization in insolvency, or we still want to feel, paper documents in our hands?
Well, I think it's interesting. I think in all of the discussion around digitalization, you always have to think about people. And when I have in my work, it's depended very much on from jurisdiction to jurisdiction. But in some jurisdictions, the average age, I think, for example, in Croatia, the average age of bankruptcy administrators is over 60. I mean, you have to look at also age and generation and this in this digitalization discussion, and it's very difficult when you have, for example, this kind of revolution that's taking place around digitalization, to bring everyone with you and to be inclusive. So I think we are embracing digitalization, but I think the process itself will not take place from today to tomorrow. It's going to take some time. Exactly how much time I don't know, but it will involve, I think, new people entering the profession, for example, of insolvency practitioners, new approaches among the judiciary and so on. I mean, it varies from jurisdiction to jurisdiction. I think the Baltics and Latvia are very much advanced. Thank you.
Yes, thank you. Thank you also for the assessment. 10 out of 10. You don't hear that about Latvia being 10 out of 10. It's really nice. Yeah. So you're
congratulations.
Yeah, thank you. So you're moving to Canary Wharf, is that correct?
We are, yes. I have to pack up the rest of my office today because we have a deadline, 6 p.m. London time. We have to we have to move, and we're moving now to quite different offices. So I think, again, reflective of the changes that businesses are going through, we will be doing a lot more hot desking. We will have more breakout spaces. I think the new design reflects the changes in the ways of working.
Right. Yeah, I mean, the area is nice indeed. So best of luck with that, and we will not keep you any longer from packing your stuff. Thank you so much.
Thank you very much. I will join and listen to the rest.
Right.
Thank you.
Thank you. All right. We shall now switch to our last speaker today. We will hear about the practical experience and insights on how the digitalization process has been implemented to insolvency in Czech Republic. And the speaker is coming from the Ministry of Justice of Czech Republic, Mr. Ondrej Zezulka. Hello.
Hello, and greetings to all of you. First of all, thank you very much for an invitation, and my sincere regards to organizers allowing us to attend virtually. So it's great. It's really digital, and I really appreciate the efforts. My presentation will concern the practical experience on how digitalization has been implemented so far in the Czech Republic. First of all, I'd like to mention that I'm a lawyer, senior counselor at the legislative department. So I'm not technically IT expert, but as usual, I guess we who are making up the legal provisions are usually those who make tasks for those who implement them in the real practice. So let's say in past years, I was involved in many IT projects, and my point of view and my angle of view will be determined by the fact that I'm like a low-level worker in the field of the ministry. So let's begin. Next slide, please. First of all, it's necessary to say that the digitalization of insolvency area began in 2008 in the Czech Republic with the new and quite modern Insolvency Act, which replaced the previous and quite ancient provisions. Having this Insolvency Act, the necessity for creating insolvency register appeared. So let's present the playground here. Let's present the stakeholders, and then as the presentation will move on, we'll see how did the digitalization affect them. On the upper side of the pyramid structure, there's a Ministry of Justice as a single and sole administrator of Insolvency Register. It's the key holder of the system. It is responsible for all adjustments to the functioning of the register. It also implements the new legislation and providing support to courts. In the Czech Republic, there are 8 insolvency courts regionally distributed all over the area of the Republic. And on those courts, there are approximately 100 judges. So as it might appear, previously and in past years, a broad variety of approaches emerged, since there are young judges that are eager to use digitalization, and well, the older ones who sticks to the standard hard copy files. Then to supplement the courts and judges, there are over 400 insolvency practitioners, which are in our system, all of them entrepreneurs. They are obliged to file the papers and documents via electronic means. In the Czech Republic, a long time ago, a system of so-called data boxes was established. That means that any person, both natural or legal, can submit any document to the state authority or court without any payment and in real time. So this is the system how that allows creditors, debtors, and practitioners to communicate with courts. And so far it's going very well. It's swift, and it cut a lot of costs. It's necessary to say regarding this that courts are maintaining insolvency files still in some sort of hybrid form. Let me explain it. As was previously mentioned by my previous speaker, Czech Republic has a dedicated insolvency register. and it's full of documents in PDF form, but parallelly, insolvency courts maintain the files in hard copy forms. So anything that will come to the court is both printed and set to the file and published on insolvency register. So this is the first, I guess, virtue of our system, which will be overcome, I hope, soon. Talking about insolvency field in the Czech Republic, it's necessary to say that there are quite plenty of proceedings opened every year. It's almost 30,000 proceedings a year. And within those proceedings, approximately 300,000 creditors applies their application of receivables. So a huge amount of stakeholders in here and huge amounts of documents and papers. Regarding this, we, as well as Poland, as Emil Štěpánek said previously, introduced standardized PDF forms for the most prevalent submissions. And so far, while calculating the impacts, more than 500,000 forms are submitted every year. So I will talk about the forms later, so I will skip this. But it's necessary to say that most of them are sent and used within the proceedings led against natural persons, against proceedings and bankruptcies whose bankruptcy was resolved by discharge from debts institute. Well, next slide, please. While thinking about the practical experience, I tried to dig into the past, and I found out that there's still an ancient evidence of bankrupts running on our servers. It's an application which predecessor to the insolvency register. It's not actually important what's on the file. It's about the visualization. This evidence was released in 90s. It was the time when the most usual connection to the internet in the Czech Republic was dial-up. So it's quite optimized to not to drain too much data. It has been terminated in 2007 as the new regulation, new Insolvency Act was introduced, and there were no new cases opened under the previous act. So it has no technical support, but still contain a lot of data, a lot of documents. This leads us to the one problem I would like to specifically mention, that it's the migration of data. When we are talking about practical experience in the Czech Republic, it's necessary to say that we are operating multiple evidences and registers which are incompatible among themselves, and we are not quite capable of putting them together, putting the databases together. So this is one practical point I want to mention. In the future, when we want to release the new systems, we'd like to standardize the data structure of behind the actual register. Next slide, please. Now we are getting to the actual insolvency register, which is currently running in the Czech Republic. It has been released in 2008, but the very application core is from 90s. This is, back then, it was a great success, and it led to a tremendous transparency of the insolvencies in the Czech Republic. But today, maintaining and operating and supporting the system of this old, of this age, is virtually unimaginable. It's really costly when you want to adjust anything. The system cannot actually be too much modified because it's rather closed than opened. And to some extent, and it's sad to say, some of original developers are already dead, and they left us without any technical documentation. So this is why we are thinking and preparing a new insolvency register, which will maintain the transparency and all other virtues, but will be quite next gen. This register had been adapted to interconnection of insolvency registers in version 1.0. As such, it allowed searching behind the European mask, but with the release of new IRI standardization, it wasn't adapted yet. So this is one of those issues and painful experiences maintaining old system. Yet for local creditors, it's quite useful because behind this front-end mask, there's a strong system of automated web services, which allows creditors just to ping the request and obtain the data without actually using the web browser. So all of the system creditors in the Czech Republic are directly connected to the very databases and data stored within the system practically in real time, which is excellent and allows to shorten the dates and time frames scheduled for procedural actions. Next slide, please. This is how the inner side of the register looks. This is the overview of the certain debtor and information on the upper side of the screenshot about the debtor, and then the list of all documents inside. So as I was saying, it maintains full transparency. It's the digitalized content of the insolvency file, and it's also available for all people, not just creditors, but publicly, even 5 years after the insolvency proceeding is dismissed. So the uses, it's very useful for creditors, authorities, and even academics looking for courts, decisions, statistical purposes, and so on. Next slide, please. As I was previously saying, we are planning to introduce a new insolvency register, quite next gen. In the meantime, now the public procurement procedure was already closed, and now the development phase has just begun. It will be programmed by IBM, so I guess it may be quite a professional developer. It shall be released publicly in 2024, and it should meet standards for modern systems. Like it has to be modular, adjustable to modern legislation. It should have advanced analytical features like direct data storage, statistical reports generation and exporting devices, and also some kind of watchdog application that allows even minor creditors to look for their own debtors and getting notified while the debtor will emerge within the insolvency register. Next slide, please. There's one thing among many others I'd like to highlight, and it's the issue of electronic forms. It's a quite important virtue of our system because it allows to cut the costs intensely within the system. Like hundreds of thousands of papers are submitted by those forms, and even for insolvency creditors, and most for insolvency practitioners, this is a huge development in past years. Before 2016, there were a lot of requirements and different requirements among regional courts. So every single insolvency practitioner has to maintain, has to keep an eye on what's required from him. And it was quite a common practice that every single type of report had multiple versions required by different courts. So introducing standardized forms, which were made obligatory for courts and practitioners, completely cut those obstacles and allowed practitioners to work nationwide, actually. Here's the story behind it. The first generation of the forms made in 2017 were made by 3 people within the Ministry of Justice. Specifically me and 2 colleagues from IT. We did it in 2 months and mostly on weekends and evenings. It was like quite challenging and really inexpensive for the ministry. We made it, but the results weren't as good as expected. This led us to the need to revise the forms, and 4 years later we've actually contracted external professional developer and made a new version of those forms. The result and experience from this is that the digitalization cannot be done without funds. It cannot be done with internal forces. It cannot be done without proper project management. So if I'd be asked to do it again, I'd sincerely refuse this time, because it's not viable strategy. Next slide, please. I will skim through these slides just to show you what was the original development of those forms. This is a final report which is used in liquidation. It's the report of the insolvency practitioner at the very end of the insolvency proceedings, highlighting the progress of the liquidation and the outcomes. So this is the form made in Excel, created in 2016 by regional courts, that has been unofficially distributed among insolvency practitioners. Next slide, please. We took that file and remade it into an actual PDF interactive form, which we made obligatory for insolvency practitioners and so courts. The very important thing here is that it contained the data layer, so it allows us to extract all the data from those reports. This feature allows us to generate tremendous amounts of internal data about insolvency proceedings in the Czech Republic. So we actually are able to calculate what's the profile of average debtor, what's the average satisfaction rate of both secured and unsecured creditors. This helps us to target the legislation, the new legislation, and even implementing the European directives. Next slide, please. And this is how the same form looks like now. It's even more interactive. It's prepared by a broad community of judges and practitioners. It's a simple single form, which is really elaborated behind as it is adjusted to multiple procedural strategies, or better than strategies, let's say, the flows of the proceedings. Like it's really versatile in this regard. Also, it's less colorful than the others. I was previously mentioning that insolvency courts keep files in hybrid form. This less colorful form allows to print it 3 times faster than the green one previous. So even this kind of small issue is really decisive when it comes to the thing that you need to print out hundreds of thousands of those forms at once. And as well as the others, it has no glitches. The previous version has, and that led to funny situations, like when we extracted the data, some debtors suddenly had millions of children and hundreds of millions of incomes, and so on. Next slide, please. So this is the last slide I've prepared. And it's some kind of summarization of our experience when it comes to digitalization in the insolvency area in the Czech Republic. The first of all, data migration. As I was previously saying, it's quite challenging to maintain 3 or more systems at once, and migration is both costly and time-consuming. So we are now trying to maintain as much interconnectability as possible, even bearing in mind to directly connect the register with the registers, like commercial register and the other ones. Also, we like to follow with new forms, introduction of new electronic forms. And there are many. As we've heard, Poland already has 800 forms. We had only 13, so there's a space for development, I guess. The main issue when it comes to digitalization, and a great boogeyman for us, is the problem of vendor lock-in. I've shown the current version of Insolvency Register and mentioned the problems with adjusting it. The problem is that we are locked in a contract that doesn't allow us the flexibility and proper and quick adjustments of the system. And when it comes to further development, it's really costly. So it's very important to bear in mind that not to be dependent on an exclusive contractor. in here. This comes to the next thing. When it comes to licenses, the operator and the administrator of the system, ministry or courts in other jurisdictions, should possess full licenses. That means that they may adjust the systems at their own or by another vendor. So it's also very, very important. I'm not sure whether it's just a hallmark of the Czech digitalization system or it's usual among others that we struggle with keeping the time frameworks, time schedules. It's really painful when it comes to the timeframes set up by grants or subsidies, and knowing that you have only like 2 years to implement and develop and implement a fully operational system. Otherwise, you are obliged to return those subsidies. So there's no time, no space for time optimism, and we've experienced this very painfully in recent years. And at last, as usual, you need proper funding. Homemade applications just are not good enough, and especially when it comes to numbers in millions, it's really worth it to invest some money to make it proper at once. So maybe this is the summarization of our practical experience. I hope I didn't get angry any of my superiors by making such feedback, and I'm open to your question. Thank you.
Right. We will not share this with your superiors, so no worries. Right. What do you think is the digitalization of insolvency a priority in Czech Republic?
Well, it's quite a priority from one simple reason, because we are developing something which is called an electronic file. That's common ground for all areas of proceedings, for civil proceedings, criminal proceedings. And because we have the most experience just from the insolvency area, we decided to test the e-file project on insolvency. So currently we are developing the system, and hopefully after some adjustments and some years of functioning, we will expand these results to other fields of proceedings.
Did you have a chance to listen to the whole conference today, for example, a Polish and Lithuanian experience, or you just joined?
I joined at 1 p.m. So.
Oh, so you heard. Yeah, the question we asked them is the same one goes to you about Czech Republic's insolvency registers compliance with the EU's regulation on insolvency proceedings and also EU's directive on preventive restructuring. So, what's your assessment about the Czech system and its compliancy?
Well. That's what hurt in past years. I believe it's compliant with insolvency regulation, and with minor adjustments, I believe it's also compliant with the directive. We shall be able to present the data. We already accept electronic submissions to the courts. So, speaking about some sort of compliance with EU legislation, I believe we are fine.
Okay, sounds good. Sounds good. You're more confident than your colleagues, say from Poland, which is good, I believe, for you. you showed us the PDF forms on slides, and the question is, where do you store these forms? The data.
Every single insolvency court works as a digital node of the matrix. Ministry maintains the matrix, but data centers are stored by every single insolvency court. So those PDF forms are stored on huge data centers, and they are, by some kind of procedure I cannot explain right now, is mirrored to the users, to the public using the insolvency register. So it's protected from data mining and stealing those files.
See, yeah. Well, regarding data mining, you as an authority, what else could you extrapolate in terms of data beyond the things that you already mentioned from these PDF forms?
Well, first of all, the amount of the data we collect is tremendous. There are tens, maybe hundreds of data fields processing by every debtor that we, disregarding the number of family members or satisfaction rate for creditors, we can tell month by month what is the progress of repayment calendar, repayment scheme, how much money specifically go to the certain creditors. We can process data about addresses, and well, it's honestly too much to process it. Actually, we are currently up to make it a project to even recognize what it's worth it to process into some statistical reports.
Mm-hmm. All right, one last one. Perhaps you could share the assessed expenses of creation of the next generation insolvency register. Do you have any assumptions?
Quite clear. It's I believe the public procurement documentation counts with, and I need to recalculate it to euros. It's 10 million euros for the whole new insolvency register.
Okay, I'm just looking at the reaction in the local audience. Is it a lot? 10 million? How much was it in Latvia? Oh, approximately. Oh, we don't know. We just don't know. Okay. Well, anyways, thank you for sharing and thank you for joining us today. It was very valuable to hear also about Czech Republic's experience. So thank you so much, Andrej.
It was my pleasure. Have a nice day.
Bye-bye. Nu, tā mēs esam nonākuši līdz noslēgumam. Es atkal pārslēdzu uz latviešu valodu. Tiem, kas nebija to dzirdējuši. Nu jā, ja mēs skatāmies uz jaunu tehnoloģiju ieviešanu kā tādu, tad skaidrs, ka tā ir izaicinājuma pilna. Tāpat laikā tās ir jaunas iespējas, un arī to uzsver mūsu šī rīta oficiālais viesis, ministra prezidenta biedrs, tieslietu ministrs Jānis Bordāns, par to, ka šādas iespējas nevar atļauties laist garām. Šajā konferencē esam pārliecinājušies par to, ka Latvijas sniegums maksātnespējas digitalizācijas aspektā tiek vērtēts ļoti atzinīgi. Un mūsu šo te digitālo rīku sistēmā jau nav tikai šis te, kā tur bija, emīts, es viņu šodien nosaucu tā. Tur jau ir visādi citādas lietas, tur ir tiesa informatīvā sistēma, te rakstīts, to mēs arī dzirdējām šodien. Tad vēl mēs dzirdējām par elektronisko izsoļu vietni, un par maksātnespējas uzskaites sistēmu, elektroniski, protams. Tā kā tur ir vesels tāds rīku kopums, un tāds kopums mums dod tādu visaptverošu izpratni un zināšanas par par katru lietu, katram tajā iesaistītajam cilvēkam vai organizācijai. Uzklausījām arī citu valstu pieredzi. Tā skaitā varbūt arī lietas, kas ir gājušas grūtāk un netik veiksmīgi, kas, es domāju, ka ir liela vērtība jebkuram, kurš jebko dara, paklausīties, kā citiem ir gājis. Un skaidrs, ka kopumā Eiropā ir vienots mērķis, vienots ceļš digitalizēt maksātnespējas jomu, un ir lepnums par to, ka mēs varam teikt, ka mēs esam tādi pirmgājēji, šī ceļa bruģētāji. Tā kā par to liels paldies visiem, kas ir bijuši iesaistīti. Vēlreiz sveicētas Maksātnespējas kontroles dienesta jubilejā 20 gadi, kas saka, lai nākamie 20 vēl foršāki. Paldies visiem konferences dalībniekiem, visiem runātājiem, visiem, kas pieslēdzās, kas jautāja jautājumus daži. Paldies. Mans vārds ir Oskars Spriedis, biju jūsu moderators šodien. Tiekamies jau atkal citā reizē. Vislabāk!